All right, so it looks like folks are joining in, so we will go ahead and get started. My name's Kristen. I'm with the Conrad Foundation, and I want to welcome each of you this morning, this afternoon, this evening to our Day of IP. We are very thankful to have partnered with the USPTO and their amazing people who have been able to, over the years, give our students really valuable insight into all things IP, patents, trademarks, etc. I am going to be welcoming Dr. Jorge Valdez. He is an educator advisor at the USPTO, where he's focused on increasing intellectual property knowledge through education, outreach, and collaborations with a broad range of stakeholders, including development of professional development programs for educators nationally. Prior to his role in the government, Dr. V, as we like to call him, held leadership positions at AT&T Bell Labs and received the E.O. Lawrence Laureate Award from the U.S. Department of Energy on behalf of the President of the United States for his pioneering work in regent generation technology. Dr. V received his PhD from Columbia University and has an MBA from Northwestern Kellogg School of Business. He holds, and count this, 33 U.S. patents, so he knows what he's talking about, and has published over 100 research papers in science and technology. Dr. V was co-founder of the Young Science Achievers Program, YSAP, a national program dedicated to empowering more young women and students underrepresented in STEM fields and careers. And all of the other presenters will be introduced as we get to their portion. But Dr. V, thank you again to you and your team for being here, and I'd like to pass it off to you now.
Great. Thank you very much, Kristen. And thank you, the USPTO and the Conrad team. This has been a collaboration for a number of years now, and we really appreciate this opportunity to speak with this amazing group of students from all over the world and educators. And we planned this to make it fun and enjoyable so you can learn a little bit about intellectual property and connect it to your everyday lives. So without further ado, I think Kristen already mentioned, if you can put in the chat box where you are from. There is a, so let me rewind a little bit. I'm gonna put in the chat box, there are two ways to follow this program today. You can either watch it on the screen, or you can, let's see, I'm gonna copy the link, and I'm gonna drop a link in the chat, okay? And if you want to follow it so that you can interact with us through this platform called Nearpod, and some of you may know about it or have used it in school, you can just copy and paste that link into a new tab on Google Chrome, right, on your Chrome browser. And then you can follow along and actually be able on your computer to interact with us throughout the day. Okay, so I'm gonna give you a minute. If there are any questions, you can put them in the chat box. So there's a couple ways. We recommend following on with a separate Google Chrome tab on the link that I just typed in. And I could see that there's already 8 students on. I see Philip, I see Jesse, I see Sawyer. Don't be shy, jump on in. But if for some reason you prefer just to follow along with the Zoom, that's okay too. So, okay, Jermaine, okay. Jermaine hello from California. So tell us where you're from, or post a picture of where you're from. You can just type it in the bar, or like Mr. Juan Valentin from the USPTO, who has a new nickname this morning. He put in a picture of his hometown, Rochester, New York. Okay, Philip, thank you for joining us from across the ocean. Alicia from Texas. All right, we have another person from Texas. All right, all right. And Ruth, I don't know, there's a map there that looks like, I don't know what it looks like. Palo Alto, awesome. Virginia, Sawyer Kim, Northern California, awesome. Silicon Valley, Bay Area. I should have known that. Thanks.
Dr. B, I think you got to approve all these so we can see them on our screens.
Oh, really? Oh, okay. Thank you. Thank you, Juan. All right. I approve all of you. All right. Very good. Let's move on. So the USPTO, the United States Patent and Trademark Office, is on social media, just like many of you, I'm sure, on this call. Like us on Facebook, follow us on Twitter, and join a national conversation by hashtagging the amazing work that all of you do around invention and innovation. Hashtag USPTO STEM. All right. Well, this is a legal disclaimer. I'm not going to read it, but essentially, in short, it states that any references that you might see during today's program that about commercial products or services are merely for education purposes only, and not an endorsement of any sort by the federal government. Okay. So today's session was planned especially for you, and we understand, after today's session, you'll be able to understand what is IP, not to be confused with Internet Protocol. IP for us is intellectual property, and I'll share what that means. Identify the different types of IP, explain why IP is important to you and your project and your career and your future. Understand how to create it and how to protect it, and then we'll give you some tips before you apply for a patent in the United States. All right. We're going to play a game, boys and girls, and some of you may be familiar with the Kahoot platform. So there's a game pen here. If you take your cell phone, if you have your phone, and you go to kahoot.it, or if you have the app on your phone, you can put in the game pin 3127907, or use the QR code that's on the screen to pull it up on your device. I'll give you a minute to log on. Let's see. Juan, I'm going to give you a link. So if you can share this page.
Share it in the team chat, please.
Okay. The Teams chat. Okay. I will do that. Okay, boys and girls. So far, nobody wants to play the game. Yes, the pin code is 7922057. That's the current pin we're using. Maybe the pin has changed. Yeah, okay. We have.
Dr. B,
no.
what would you like me to do? I went to this link. Look, this is where it's taking me.
Yeah, maybe you have to run it on your end.
So I think
unless I share my screen.
Well, if I just go to this pin, won't it see it? If I just
no, that's an old pin.
So what's the pin? I'll just go to it right now. What's the pin?
Yeah, 7922057. So I'm gonna put it in the chat box so that you guys can. 7922057. That's the Kahoot pin for now.
Join, play.
There we go. We got a couple students.
All right, what's the
Jane is
answer?
792-2057. We have Chris, we have Jane, Philip, Amrutha, Ahan King. All right. Obi-Wan Kenobi. All right. Now I'm gonna see if, I don't know if you guys can hear the music. Can you hear the music? Give me a thumbs up. Nope. Okay, that's okay. We'll do it without music. Sometimes the music gets a little. All right, anybody else? No other takers? All right, we have 7 players. There's a lot at stake here. Big prizes. I'm only kidding. All right. So 3, 2, 1. Let's get started.
Is the sound gonna work?
I'm not sure. We'll give it a try.
So we're not seeing anything, Dr. B. We have to look up. You're playing it on your side, so you have to share your screen.
Okay, why don't I transfer to my screen? I'm gonna go. Okay, I think you have to stop sharing. Thanks, one. We'll give it a shot. I'm gonna go share system audio, but I think that's gonna put me on mute. But let's see. Give me a thumbs up once.
Thomas Edison's electric lamp, Orville and Wilbur Wright and their flying machine, Walt Disney's Art of Animation camera, Steve Wozniak and the microchip for use with video display, Stephanie Kwolek's protective fabric, even Michael Jackson's method and means for creating anti-gravity illusion. What they and many others share is something called innovation.
Students are designing and building candy bridges. We started by introducing them to different types of bridges.
Whether it happens among students in a classroom or engineers in a laboratory, innovation is a process, a series of steps that begins with imagination and results in the creation of something of value for society.
Innovation is improving upon the knowledge and the information that's out there and taking what is already known in the world and improving it, making it better.
Okay. What is innovation? Since Dr. V cannot unmute, what do you think innovation is? Lots of choices. Dr. V says 30 seconds. Make sure to select your answers. Kahoot is time-based as well as accuracy. Oh, we got big prizes. From Dr. V, not from me. That's from Dr. V. I'll give you his contact information afterwards so you can chase him down, get your big prizes. Here we go. So Dr. V cannot unmute. You can't click unmute, Dr. V. Very strange. Okie dokie. So, got a lot of good answers here. You notice red, blue, and green are all correct choices. Not a brilliant idea, technically. There's a little caveat to that. We'll talk about that, I think, on the next slide. First, we're going to get some scoreboard here. Great job, Jane. Quick with the selections. Great job. All right. It's a good leaderboard. So why wasn't a brilliant idea not correct in this instance? So it's more than an idea. Innovation begins with an idea. So it's not that an idea does not have anything to do with innovation, because it obviously does. But in order for it to be an innovation, you want to have that idea, right, to initiate that process of innovation. But then you have to take it and move it along the way to bring it to something where it has value, it has reality, and you're designing it, you're building it, you're testing it, you've actually brought it to market, you've actually changed the marketplace, done something with that idea, right? So you have to curate that idea and turn it into something. And that's where we're going with the innovation, working together in teams, all those answers. So now we have another video that we're going to watch right now.
Examiner at the U.S. Patent and Trademark Office. Headquartered in Alexandria, Virginia, the USPTO is an agency of the Department of Commerce that employs more than 8,000 patent examiners, many of whom are scientists and engineers.
It is the agency in the United States government which oversees patent and trademark functions.
A patent gives the inventor the right to exclude others from making, using, selling, or offering for sale their invention without permission for a limited period of time. On average, the USPTO receives about 500,000 patent applications a year. It also registers trademarks, which help designate the source of products or services.
The trademarks can be logos, brand names most commonly, but they can also be colors.
A trademark can be almost anything: characters, shapes, and even sounds, such as NBC's signature 3-note chime.
All right, quiz time. Hope you were paying attention. A lot of good nuggets in that video clip. What is a patent? Check all that apply. What is a patent? I see a lot of excludes in here. I don't see any of these answers that let me do something. It's very interesting. 30 seconds left. Dr. B wants me to remind you, he's got big prizes for the winner here. Dr. B, you better jump on Amazon real quick. Same day delivery, Dr. B. Hopefully this snowstorm doesn't get in the way. All right, 6, 5, 4. What do we got here? Yes, that's innovative, drone delivery. There you go. Ooh, oh, quick. Dr. B's quick. Oh, King pushes to the top of the leaderboard. It's close. Super, super close. Good job, everybody. Good job, everybody. If you didn't catch it, all 4 of them are right. Dr. V, you went through that slide a little fast, but all 4 of those answers were right. So what is a patent? Notice the very top line. It's the right to exclude others, in bold print, exclude others from making, using, selling, offering for sale, or importing the claimed invention into the United States. So it's an exclusionary right. You have the right, once you have a patent for an invention, you have the right to exclude others from doing anything with that invention without your approval, without your prior approval. So you can stop people from making, using, selling your invention. Notice it does not necessarily give you the right to make your invention. And those, I think we can talk about a little later. Patents are limited terms. They're territorial. There's no such thing as a worldwide patent. If you get a United States patent, it's good in the US and its territories. All right, so that's important to remember. Patents protect inventions. There's these 3 different types of patents that you see on the page here. We have a design patent, which just, it's like the name implies, you're protecting the design, the ornamental shape of the object or the product. You have plant patents, you know, and those are for things that are created in a laboratory, or you're basically taking 2 plant varieties and you're splicing them together, you're grafting, however the botanists do this. I'm not a botanist, I'm a mechanical engineer. By the way, I probably should introduce myself. I'll do that in a slide or 2. I am and then the third one is a utility patent. So when you hear the word patent, 90% of the time, 9 out of 10 times when someone uses the word patent, they're talking about a utility patent. And we're going to talk in the coming up slides specifically what a utility patent is and how to get one. So those are patents. Now we have another quiz. Pay attention. What type of patent do I need to protect the structure and function of the robot shown in this picture? Structure and function. Structure and function. Now, I didn't really talk about this too much in the last slide. Yes, we can hear the music. Yes, we can. Thank you. Did you come up with this composition yourself, Mr. V, Dr. V? Plant patent? Looks like there's a lot of plants in that picture. There may be some patent pendings in there. Hard to tell, though. Hard to tell. I don't know. Am I giving away too much? There we go. Utility patent. Structure and function. And we'll talk more about what that means in terms of utility patents and structure and function later. But the correct answer, good job to those who got it. Let's see. We have a new leader, a 3rd leader. We keep swapping leaders. Great job, Chris. We got Willie with the fire next to his name or her name, their name. Good job. All right. Willie's moving up the leaderboard. Another quiz question. What type of patent do I need to protect the shape and look of the car being built by the robots in this picture? So now we're talking about the shape. Now, shape could have function. Two seconds left. Get your answers in. Big prizes coming back. Oh, 10 out of 10. I love it. Good job. Good job. All right. So Jane was the quickest on that one, because remember, Kahoot is time-based as well. So not only did Jane get the correct answer, but they did it the fastest and shot up the leaderboard. Welcome back to the top, Jane. All right, here we go. What type of patent was used to protect this Haas avocado? Ooh, Haas avocado. Nonsense. You cannot protect fruits with patents. By the way, I think that might be my next Halloween costume. Be an avocado. All right, answers in. Excellent, plant patent. Now, who was the quickest to get that, though? That's going to determine our new leader. Who was the quickest to get it? Ooh, Jane is on fire. On fire. Moving up. Great job. All right, multi-select. More than one answer. Which of the following can function as a trademark? Now we're moving into trademarks. The video did talk about trademarks. Which of the following can function as a trademark? Now remember, trademarks are source identifiers. They identify the source of services, products and services, and distinguish among competitors. Or is it a word, a symbol, a logo, a slogan? or a jingle? I wonder. Remember, this is a multi-select. Okay, nice. Ooh, let's see though, who's quickest? Who's the quickest here? Oh, Jane, by the slimmest of margins, holds on to the lead. Great job, great job. Willie, close second. All right, so what is a trademark? Like I said previously, it's any word, symbol, name, or design, or any combination of those used to identify the source of products and services and distinguish them from other sources or other competitors, right? And so anything that identifies a product or a service, right, or can help you distinguish one product or service from another qualifies as a trademark. They come in many different forms. You'll see these symbols at the bottom of the screen: TM, trademark, SM, service mark. They're registered, the R with a circle on it means it's registered with the trademark office. It's a federally registered mark, and they come in all different shapes, sizes, varieties. So, all right, let's watch this video clip. Pay close attention. There's some clues in here for the next question.
And the simple desire to address a particular problem or need.
You have to see what's out there and see a problem that you want to fix, and then you have to come up with a way to fix it.
Figuring out a new technique, a new method, a new combination of existing things can be innovative.
Beyond just an idea, innovation also often requires financial support. In the U.S., many innovations are funded by government agencies, such as the National Science Foundation, as well as by private companies, foundations, and other institutions. The NSF, an independent federal agency, issues about 10,000 grants per year for research and education in fields of science and engineering.
We write a proposal to National Science Foundation to explain this is our idea, to explain how the device or science will benefit society.
Beyond imagination, research, and funding, innovation also requires vision, persistence, and involvement of people from different backgrounds and varied expertise who collaborate in order to create a new product or process, something that may solve a problem in a new way.
Teamwork is important because now you have many eyes on the same problem from a different angle. Teamwork is so essential that I would say without any hesitation that it won't happen without teamwork.
And you don't really know where the shortcomings are, where the most powerful refinements are, until you actually go through the process of doing the experimentation, building the devices, doing a few design iterations.
Okay, what does innovation require? That was a great video clip from our Science of Innovation video series, talking about what innovation requires. Now, this is a multi-select. I would like to remind you, you have the option of selecting more than one answer. So we have imagination in red, persistence, vision, collaboration with people having different expertise. This is a tough one. Got 2 seconds left. Get your answers in. Will Jane remain atop of our leaderboard, or will Willie finally overtake the top spot? Oh, close. Ahan moving up, inching closer to the top. Jane holds on. Great job. All right, we have another multi-select. Why is teamwork so essential to innovation? I like that picture. A lot of teamwork went into making that picture. Dr. V, check the chat real quick for me. Why is teamwork so essential to innovation? This is a multi-select. "30 seconds left, 25 now. I don't know. All right. Let's see, 5 seconds left. Why is teamwork so essential to innovation? This is a tough one. Ooh, nice. Nobody selected Green, great job. All right. Oh, the fire symbol is back. Jane is getting a bigger lead. Her lead expands. All right. Great job. All right, let's watch
the
this.
inventor is required to fully disclose the necessary details about the idea, which is then investigated by a patent examiner. The patent examiner conducts a thorough examination of previous patents, scholarly journals, the internet, and other sources to ensure the invention is new. During this process, the inventor is often asked to make revisions to the application to help clarify the invention and distinguish it from others.
There's a lot of give and take with the patent examiner so that their job is to help you craft the language of these claims so you're not overstepping onto somebody else's property.
It takes quite a bit of time to do all that searching and to produce office actions, allowances, rejections for each application that's handled here at the office. Right now, the average filing to first action for a patent application is about 23 months.
All right. What is the role of a patent examiner at the United States Patent and Trademark Office? Quick little nugget of information. Mr. Calvin Hewitt and myself are former patent examiners. Calvin is a supervisory patent examiner now. We're lucky to have him on this call. I have since left my role as a patent examiner. So 12 wonderful years though. So what is the role of a patent examiner? Do they conduct examination of previous patents, journals, and internet and more? Do they judge if an application for patent is eligible to receive a U.S. patent? Do they prove that your invention works? And lastly, they are to test your invention and prototype in a laboratory. Does the Patent and Trademark Office have buildings full of laboratories to test inventions? 9 seconds left. 5, get your answers in. This is a multi-choice, folks, multi-choice. Will Jane keep her fiery answer streak going, or will Willie finally overtake the top spot? All right, notice there are no laboratories at the PTO, except for bathrooms, if that's what you call them. All right. I missed who was in front, but here's another question. Jorge's flying through here. We must be on a time crunch. All right. Infringement is when someone sells, imports, uses, or makes a product that is already patented without permission. True or false? Infringement is when someone sells, imports, uses, or makes a product that is already patented without permission. You never want to see a judge. You never want to go in front of a judge for intellectual property related issues. True or false? I don't know who's in the lead right now. I didn't see the answer to that last question, so I'm going to assume Jane has remained on top. 8. Okay, so it is true. Infringement is when Willie had the top spot, but Jane took it back. Oof. All right, we're close. Neck and neck. Look at those scores, folks. This is great. All right. The innovation process ends once a patent is granted by the USPTO. Does innovation end once you get that patent? True or false? All right, 7 answers. We're still got, I think there's at least 10 people in this Kahoot. So there's 3 people, still 2, 1. All right, we're waiting on that last one. Number 10, what do you think? True or false? The innovation process ends once a patent is granted by the USPTO. It's going to be photo finish, folks. They did not get it in time. All right. Who has the lead? It's false. It does not end. Innovation does not end when you get the patent. In fact, I would say it's just starting. All right. After receiving a U.S. patent, you can improve your invention and potentially receive a new patent for your invention. This is going too fast. I don't know who's in the lead, folks. It's crazy over here. Pandemonia. This is awesome. After receiving a U.S. patent, you can improve your invention and potentially receive a new patent for your invention. True or false? After receiving a U.S. patent, you can improve your invention and potentially receive a new patent for your new invention. Oh, I've got an update on the side here. Jane is still up by about 300 points, but there's been some movement in the spots just below Jane. So don't get comfortable at the top, Jane, because this is far from over. True or false? Oh, we had a lot of time for this one, huh? All right, here we go. The answer is true. You can potentially improve your invention and resubmit a new patent application for that improvement, and you could get a patent on that. Let's see. Oh, Jermaine flying up the leaderboard, but Jane, by the slimmest of margins, holds on to that top spot. All right, Willie's still on fire, though, so don't count Willie out just yet. Here we go. To receive a utility patent from the USPTO, your invention has to meet 3 requirements. Now, this is a statement. This is not a question. This is fact. All right. Your invention has to qualify for these 3 requirements. New, we call that novelty. It has not been invented before. It has to be useful. We call this utility. It has to qualify in one of 4 statutory categories: a machine, a process, or a process of doing, a process of making, or a product that's made, or lastly, the 4th is a composition of matter. And then the 3rd requirement that you must meet is non-obviousness, non-obvious. The invention cannot be obvious substitution for something that already exists. So it's, and we call this obvious to someone in the same field. Those are layman terms, but someone of ordinary skill in the art is actually how it's worded. So those 3 requirements, and we will talk about those. I believe Mr. Calvin's going to talk about those later. So innovation is the process that helps us blank. Innovation is the process that helps us what? Imagine, invent, improve, inspire. Now, I believe this is only a single answer. This is not a multi-select. So this is a little more difficult question. We have increased towards the end here the difficulty because we really want Jane to struggle to hold on to that top spot. Can you do this, Jane? I'm still wondering what this big prize Dr. V has for you. So whoever that top winner is. Oh, Dr. V says he thinks it's check all that apply, because normally it says it at the top, but this one doesn't say it. So we'll see. If it lets you select more than one, then go for it. All right, here we go. Imagine, invent, improve, inspire. They all start with an I. It is all of them. It is a multi-select. Look at that. All right. Here we go. What's this leaderboard say? Jane, yes. I think Jane is pulling away. King rises to the top. Jermaine remains with the fire logo. Jermaine, stay hot. Stay hot, Jermaine. All right. Is that done? Or are we? Oh, we're still going. Here we go. We got another one. Multi-select. Here we go. How do patents help inspire others to innovate? All right. This is a multi-select. How do patents help inspire others to innovate? Sharing the knowledge helps others improve upon inventions that exist. Sharing the knowledge inspires others to create new inventions. I think that's part of the reason why the patent system was born. Patents inspire innovation because they are confidential and not published. Interesting. Inventors are not required to disclose how to make and use their invention. That's at odds with the blue one of sharing the knowledge. That's the opposite of sharing knowledge, actually. So interesting. 8 seconds left. We have all the answers in. We have all the answers in, so we are just waiting for this clock to run out. The answer is blue and red, right? The patent system is all about sharing. Innovation is all about sharing, because once you innovate, you want to inspire others to be innovators as well. So we're going to share the knowledge of your innovation with others so they can read about it, they can learn from it, and they can have ideas to improve it in their own ways. And that's the beauty of the US patent system, is the fact that we share everyone's knowledge with each other so that they can be inspired to create new and better things. So it's blue and red. And that is the end. We don't have the leaderboard here, Dr. V. We can't see the leaderboard. Conrad, oh, here we go. Introduction to IP. King, come in third place. Ahan, second place, and number one for the big Dr. V prize, who no one knows what it is. Congratulations, Jane. Congratulations. Woo, man. And runners up, Jermaine and Willie. Great job, everybody. Everybody, excellent job. Kudos to you on a well done Kahoot. This Kahoot was not easy. Very, very challenging. So congratulations to all. Thanks for putting up with me during this segment. All right, here we go. Dr. V, I'm kicking it back to you, I think.
All right, great job. Great job, students. Awesome. Congratulations to Jane, Ahan, King, and the runners up. And thank you for hosting and walking us through that Kahoot game. Ahan did a great job. All right, we're gonna move on. And let's see. Juan, can you share your screen on the Nearpod, and I'll advance on my end. So that was a little bit of an introduction to intellectual property, and thank you, students, for playing along with us on this. And let's see, there we go. All right, fantastic. So a little bit about the USPTO. That's our campus there in Alexandria, Virginia, which is right outside of Washington, D.C. And at the USPTO, we do three things. We issue or grant patents. So we do patents. We register trademarks. And we also, the third thing that we do is we advise the administration and the executive branch on matters that relate to intellectual property. And that includes not only patents, but also trademarks, as well as copyright policy. Okay. All right, so you might be wondering, so what? Why does invention matter, and what does this mean to me? So, you know, some of the things you need to think about is patents help promote innovation, right? Because it helps to safeguard the innovation through protection. It helps companies grow. It benefits the community because as these companies make new goods and services, they make them available to all of us. Right. They also provide personal growth, development, and advancement. And students, all this is good for you and your career. And before you know it, you will be entering the workforce. And so having a knowledge about intellectual property and innovation is going to be key. And I know a lot of you have done some extraordinary projects this year, and I've had the pleasure and opportunity to actually review some of your works. I'm super, super impressed, and great job to all of you who have made it to the finalists. All right. So when you think about patents, what's the first patent? This is the first patent was issued on July 31st, 1790. And you see a picture of it here. It's an old kind of piece of paper. It was issued to Samuel Hopkins for a process for making potash, which is an ingredient used in fertilizer. What's really cool about it, and you really can't see it, you'd have to kind of blow it up, but it was signed by President George Washington. It's pretty cool, right? So since this first patent, there's been, you know, over 10 million patents that have been issued by the United States Patent and Trademark Office. And the original document actually for this particular first patent by Samuel Hopkins is in the collection at the Chicago Historical Society. So pretty cool. And that's a picture of potash. All right, I wanted to share with you, thank you, Kristen, for that lovely introduction. I spent most of my career before joining the federal government in the private sector at AT&T Bell Labs, where I was an inventor. And throughout the years, I learned three things. I want to share those with you today. All right. The first thing is don't believe everything people tell you. Don't believe everything people tell you. And I think for your generation, and in the world that we live today, we're constantly being bombarded by all this information. It comes through all these channels, social media and so forth. And it's a tough job to figure out, what do I believe? Who do I trust? Right? So that's my tip number one. Don't believe everything people tell you. So, and some people can be doubters, for example, right? Have you ever heard someone tell you that it couldn't be done? Many inventions were made, even though some people said it couldn't be done, couldn't be done. But as inventors, we say, I can do it. We can do it. So in 1895, Lord Kelvin, Royal Society, president of the Royal Society in the United Kingdom, said, heavier than air flying machines are impossible. And I would say to that, say what? This is a picture of the Wright brothers' first airplane. So don't believe everything people tell you. The second example here is from 1949, Popular Mechanics. Big, very popular. I don't even know if it still exists, but it was a cool magazine. And it quoted, in the future, computers will weigh more than 1.5 tons. Now, the picture that you see here, and this is a man saying, you can see this is a big computer. This is actually the ENIAC, which stands for Electronic Numerical Integrator and Computer. And it's the first programmable general purpose electronic digital computer, and was built during World War II by the US. And then after this came mainframes that are used today. They're high performance computers, lots of memory, lots of processors. They're critical to, when you go to the store and buy something with a credit card and go to the ATM and get cash. These are driven a lot by high performance mainframe computers. And then we got the PC, and then we got the laptop, and they became lighter and lighter. We've come a long way since Popular Mechanics at 1.5 tons, right? And some of the microprocessors that we have today are really tiny chips. I mean, how many chips are on a cell phone? And you think about not only cell phones, but Game Boy, CD players. So a lot of stuff. Don't believe everything people tell you. Here's another interesting one, boys and girls. I think there is a world market for maybe 5 computers. That's funny, right? Said by the chairman of IBM in 1943. Now I might say, oh, way before I was born, but that's not that long ago. Say what? Could you imagine a world where the cell phone or the telephone or those types of communications didn't exist? Western Union, there was an internal memo. This is long ago, though. And it said this telephone has too many shortcomings to be seriously considered as a means of communication. This device is inherently of no value to us. Really? Say what? Don't believe everything people tell you. And so in the chat, I want you to guess, see if you can guess who might have said an amazing invention, but who would ever want to use one? Go ahead in the chat and see if you can guess who might have said that. So Mike, yes, the slide should be advancing. And you could also follow along with the shared screen. So anybody, any guesses? Rutherford, yes, absolutely. So President of the United States of America. But what's interesting is that he said that after making a call from Washington, D.C. to Pennsylvania with Alexander, here's a picture of Alexander Graham Bell, with his telephone that was patented back in 1876. Fascinating. Don't believe everything people will tell you. The second tip I have, and I'll be quick on this because I know we have a lot to cover today and a lot of great things that we want to share with you. I learned from the amazing mentors that I had, and I was so fortunate to have at Bell Laboratories, Jim West being one of them, who said, asking the right questions and being curious about the world is really so important. And you can Google this, the golden circle. But, the bullseye, the kind of questions you want to ask are the why questions, right? You can ask what, those are important, and how, that's important. But understanding the why behind is really critical. And oftentimes it's not as easy as you might think, right? So thinking about asking the right questions. And if you think about it, right, the telephone here on your left maybe was your grandmother's telephone, your great grandmother's telephone, but look how it has evolved. Today we have smartphones, we have phones that are on our wrists, on our rings, all kinds of really interesting, evolution of technology. And that, in large part, that innovation was enabled because someone invested, and the companies and individuals protected those investments with intellectual property patents and other forms of intellectual property that we will discuss. So here is me standing by my first invention for a new process for the manufacture of high-speed electronic and optoelectronic devices. So these are the things that make essentially our modern internet and streaming networks possible. This patent was issued by the USPTO back in 1995. I was 5 years old back then, boys and girls. I had hair, I had a mustache, and for this work, I got a nice medal from the president of the U.S. that's shown here on the right. So I got this invention, and I show the tip here, because it took a lot of failures to make it work. So my third tip is don't be scared of failing, but when you do, fail fast. The faster you fail, and fail forward. And by that I mean learn from your failures and move forward. One of my favorite quotes from Thomas Edison goes like this: many of life's failures are people who didn't realize how close they were to success when they gave up. So never give up. You never really know how close you may be to success. Just to recap, don't believe everything people tell you. Make sure you think about asking the right questions, especially the why question. Don't be afraid to fail, and learn from those mistakes and move forward. All right. I hope those tips are useful to you. I'm going to switch gears back to Mr. Valentin, and he's going to take us and walk through a little bit more information about intellectual property.
Thank you, Dr. B. I apologize, everybody. My power went out, so we're dealing with it. All right, so demystifying intellectual property. Let's go ahead. We got some open-ended questions for you to answer here on the screen real quick. In your own words, what do you think intellectual property is? So we've talked a lot about intellectual property and the Kahoot. I'm not sure if we necessarily use the word intellectual property before right now, but in your own words, what do you think intellectual property is? Feel free to type your answer on the screen and go ahead and submit those. Intellectual property. 2 words, 2 different meanings. When combined together, means something. Intellectual and property. And for those listening, I am not on the chat anymore. My work computer is on the fritz. So I am flying solo on my personal laptop. What is intellectual property? IP for short. It is not internet protocol, as Dr. B said earlier. Intellectual property. How are we looking, Dr. B? What kind of answers are we getting?
I don't know. I don't see any answers from the students. I don't know if it's because you can't.
No answers, huh? There's at least 10. There's 10 students on the Nearpod, right? Jane,
18.
Willie,
We're up to 18.
Jermaine. I know you're out there. You're playing the Kahoot.
I don't know. Well, I think we should move on because I don't know whether there's a glitch or.
Okay, well let's keep this party moving.
Let's keep the party moving.
Intellectual property. When we talk about intellectual property, we're talking about creations of the mind. We're talking about the intellect, right? Using your brain to come up with these great ideas. However, the same thing with innovation. we talked about earlier, innovation's more than an idea, right? You get that brilliant idea using your intellect, your brain, but then you got to download it. You got to take it out of your mind and you got to do something with it. You got to turn it into something that can be real. All right. You have to turn it into a drawing, a picture, creating a prototype. It could be a working model, doesn't necessarily need to be a working model, but you have to do something with that idea to bring it to life. All right. And so that's when we're talking about intellectual property. We're talking about creations of the mind. All right. Go for it. Thank you. And in terms of in U.S. Intellectual property law, we talk about 4 main types of intellectual property, and those are patents, trademarks, copyrights, and trade secrets, all of which we'll talk a little bit about with you this morning. I already said this, but they're creations of the mind. You don't only get to choose which one you want to use. If you have a good business and a good business plan, you're going to want to probably incorporate at least 2, 3, maybe even all 4 of these intellectual property components into your business plan to create and protect your brand. All right. So you're not just limited to only 1 or 2. You can use as many of these as you would like. All right. Intellectual property. IP's everywhere. So what I want you to do right now is before, when we say go, don't do it right now, but when we say go, we're going to give you at least 10 minutes, maybe 15. I'm not sure if we're running behind. We might cut this short. We want you to go around your house and take pictures of all the different kinds of intellectual property that you can find inside your home. And we want you to upload it to Padlet. All right, Padlet is a website. You don't need to create an account. We're going to give you a link, and you're going to go to that link, and then you can go. If you have a phone, it's even better from a phone, or if you're on a Wi-Fi with a tablet, and you can go to this link. You can click on plus and just take a picture of it and add it in there. So we want you to take pictures of all the different things that you think are protected by some of or more of these forms of intellectual property. Miss Kathy is going to drop the link in the chat. But if you're not on a smartphone, then we're going to need you to actually see Jorge, Dr. V, they're going to need to type it if they're on a phone. So can we have that link really quickly?
I don't have the, well, I could get you that link.
Oh, you took
right
the slide
now.
out?
But if you go up to the upper right-hand side, you can invoke the QR code also under share. Upper right, click on share, and then you can get the QR code there. I'm also putting the link to the Padlet right now.
I'm sorry, Dr. B, I'm a little confused.
On the upper right, where it says next to login, share. If you click on that.
Can you do that right now, and they can take a picture of your screen with the QR code?
I'll try to pull it up. I thought it was on a slide.
Yeah,
hang on.
Like Dr. V, if you go to share on your screen right now, can you pull up the QR code so people can just take a picture of their screen?
Yes, I could do that.
Or is this just a picture of a screen?
No, that's just a picture of the screen. But I have to share. Okay, but you have to stop sharing your screen. But the link to Padlet is on the. Okay, let me share my. If you can give me control back, Juan.
I haven't been sharing my screen since my power went out, Dr. B.
Oh, okay. Let me share. Disable. Someone else is sharing. Chris, you're sharing. I think you have to unshare so I can share mine.
Okay. Yeah. Let me do that now.
See if I can find it too.
All right, I got it.
You
Here
got
we go,
it?
boys and
Okay.
girls. You see the QR code? Can someone put in the chat that you're able to use the QR code to connect up with Padlet?
Yep, it works.
All right.
And then all you have to do is when you take a picture of your IP, you just put a plus. You click the little pink plus, and then once you do that, you can find the camera at the bottom. It's the second green image on the bottom, and then you just take a picture. So let's see.
So should we combine this activity with a little break as well? We're going to give you 10
Yeah,
minutes.
because you're going to be up moving around. So this can
Yeah,
be
you
your
can be
break
up and around.
too.
Go take a quick rest break, get some water, a little coffee if you need some. But take some pictures and then upload them here, and they'll pop up here when we get back in about 10 minutes. So it's 10:10 now. We'll be back at 10:20.
Real quick, Dr. V.
Yes.
I'm on my phone here. I scan the QR code. I'm not seeing a plus sign here on my screen to add anything.
Is it a little pink circle down in the bottom right corner? One?
No.
Oh, you're on the screen already. So go down to the camera.
Go down to the camera.
Yep, and then you can just take a picture. And then it'll ask you if you want to publish it. So Dr. V, if you go back to the screen, back to the, you want to leave that up. Yeah.
I think we have, yep. There we go. We have.
You probably want to
have it
leave your QR code up. Right?
So who's sharing the screen here? Who's sharing the screen right now?
I am scared.
Oh, so Dr. V, go to your screen and try to add something from your screen.
I just added a picture of a.
Yeah, I saw Kathy's, but Dr. V, from this screen, how do you add something?
Oh, from here?
Yeah.
You go to the little three dots. Is that where it is? Or Kathy, can you help me?
Well, you probably just want, honestly, just do it from your phone because it takes a long time.
I'm trying to walk people through the process of doing it.
Yeah. Okay. So
I'm on
now,
my phone and I don't see anything.
So now you've
here.
got it. One, you'll go to you'll put a comment in there, and then it should pop a publish image that come up.
Yeah, Kat, I can't do it, Kat. That's why I'm asking, because I don't know.
Okay, show me your phone.
There's
Oh. Okay. Go back to the. You gotta take a picture of the QR code.
There might be a setting in there, Kathy, that you have to unblock so others can add to it.
No, because I just did it off my phone.
Anybody?
Someone commented. Someone commented. Nice copy. Yeah.
Yeah. So.
Yeah.
You go to the QR code. Take your camera. Use your camera from your phone, and put it up to that QR code.
Yep, that's what
on your screen. On your screen.
Yep.
No.
Yep.
Yeah.
That's what I did.
Okay. On your computer screen, can you take a picture of your QR code? Just hold your camera up so it's got the QR code in it.
Yeah, that's how I got there the first time. That's how I got to your page. I scanned the QR code. But I'm not, and I don't see where Jorge has that option either to post anything. So I
have it on my phone. Is it make?
So let's see. I don't know why it worked for me because I'm not on the, I guess the only thing is the internet. Let me see. In the chat, it doesn't let me either. Okay, let me go back and see why it's doing that.
And we apologize, everybody. We're working this real time. This is
that's
how innovation happened.
It's called troubleshooting in real time.
In education. Okay, hang on.
Do we need an account, maybe?
No, it's probably, you're probably right. It's probably something settings, copy clipboard. Comments allowed, reactions not to require approval. Huh. I don't see anything that would be blocking it. Okay, let me share it again.
Okay.
Get QR code.
There is a little dialogue going back and forth on this cup, and the question is what form of IP could protect this. Someone wrote patent, And then someone followed with most likely a design IP, a utility IP doesn't seem viable. So a design IP, I think that design patent is the way something looks, the ornamental design of something. So it could potentially be, if it's unique and novel enough, it could be a design patent. Although you never know it.
Yeah. It looks like it has a lid on it. So that lid potentially could be a separate invention, a separate,
Yep.
And maybe there's something special about that lid, the way it allows liquid to come out of it, or the way it shuts to keep liquid from spilling over. Maybe, I don't know. Why don't we give people a 5-minute break, come back, and then hopefully we'll have this worked out by then.
Yeah, that's a good idea. Yeah.
Sounds good.
And they can look for IP and then go back and take a picture if they want.
Take pictures later. So it's 10:15, so come back at 10:20. Everybody, please.
So I don't know why it would work on my end.
So one of the students said there should be an add button.
Yeah, there should be at the bottom of the Padlet, but there's not. So I'm going to send you this QR code. See if this one works. I just emailed it to you, Jorge.
Okay.
I should email it to Juan too. Sorry.
I'm sharing, so yeah.
Okay, yeah, so if you share that, let's see if that one works.
Okay.
I'm not really sure why. ID, IP. Okay, change privacy. Public, okay. So try it now. I think I had it set. I think you were right, it was a setting. Sorry about that, jeez.
Okay, so I have the QR code here, the new QR code from Kathy. Let's try that one.
So this is a brand new Padlet?
Yes.
No, it's the same Padlet, just a new QR code, I believe.
So maybe if we refresh it.
Let's see.
It should do it automatically. So go ahead and do the QR code one, take a picture of the QR code and see if it brings up the screen with the plus sign. You shouldn't need to.
Okay, let's see.
Refresh it. I don't think. So, okay.
Okay, I got the Padlet. And
So did a little pink circle come up at the bottom right-hand corner?
No, on my phone, no.
No, I don't see it either.
Okay, hang on. So try it now. Maybe. Oh, wait. Why it's doing?
Yeah,
Okay,
we don't see the plus.
Hang on.
Okay.
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 Okay. Okay, try it now. Refresh this. It should just do it.
But it isn't that will only change the QR code?
No, I think you can just use that QR code.
Okay, let's see.
It works now. Good. Jermaine.
It works. Oh yeah, excellent, excellent.
Okay.
Yeah, it does have
All
a
right.
plus sign, boys and girls. So
sorry, settings are a
No
little
worries.
different. They adjusted the
No
way you do
worries.
that. So sorry about that.
Let's see here.
You press the plus sign and then you put the camera. You press the camera button
Nice.
and I'm gonna.
All right, there we go. Boom. We are in business. All right. Great. So we can tell them when they come back in a minute. Hopefully. There we go.
Now I'm gonna go and look around. Let's see what other things I can find. Oh, I have one right here. Oh, air pure. Oh, I love those air purifiers.
Dr. Reed, let's see what they come up with. You're going crazy over there.
I'm
You're giving away all the hints.
well, I'm taking pictures. I'm gonna take a picture of my dog.
So are we going to give them till 10:30 or to do this, or 10:25? What's
10:25, I think.
all right, everybody, if you can hear us, 10:25. Race around your house, take those pictures. If you can, identify the type of intellectual property you think it is in the caption before you post the picture. Otherwise, we'll go back and do that later. But yeah, let's see what you can come up with. Dr. B, can you close that sidebar menu on your screen?
Juan, your clock is an hour ahead. Okay, boys and girls, one more minute for your pictures. A lot of really cool pictures there. Juan, are you on the Teams chat? Joyce, can you hear me? I can't hear you. No, I can't hear you. Juan, I can't hear you. I think you're on mute also. So we have a lot of great examples, boys and girls. It's about 10:25. I see a lot of really cool examples of IP. Wow, someone's got a 3D printer, snap maker, box of cereal, a bug, an air purifier, a Google Home, ice cream, a Logitech roller, ball, mouse, an iPod, a Frisbee, a projector beam. All right, we're going to revisit this a little later on. I think we should probably move on. I don't know if my colleagues have lost power.
I'm back. Is it?
You're back?
Yeah.
Yeah, we're gonna take a look at this a little bit later, but some really great examples. Lot of really great examples here that the students have put forward.
And feel free to add to it, throughout the morning. Feel free to add to this if you come up with new ideas.
Okay, in the interest of time, we're going to keep going. And so, no, Joyce, I think we can't still hear you. All right, we have a little quick question here. What historical document gives inventors and authors the exclusive rights to their respective discoveries and writings? Boy, that's pretty long. There are important documents here for those of us in the United States or even around the world who may be joining us today. These are, well, 3 of them are important US documents. Which of this document gives inventors and authors rights? So go ahead and select. I believe this is a poll. I'm going to switch over to the student view. And there are names here. I don't know if we've lost the students. The students back. We'll hide the names.
We can do better than three folks. So if you hide the names, you can't see the answers?
Yeah, I guess it's
Different.
yeah. So answer A is Bill of Rights. B is Declaration of Independence. C is the U.S. Constitution, and D is the Treaty of Versailles. A seems to be a very popular answer, the Bill of Rights. Well, it kind of makes sense, right? Because rights, yeah, I think yeah, I would be leaning on that as a possible answer. The correct answer is the U.S. Constitution. And in the U.S. Constitution, if you look at Article 1, Section 8, Clause 8, it says Congress shall have the power to promote the progress of science and the arts by securing for limited times to authors and inventors the exclusive right. It is the only right that's called out in the United States Constitution, and it pertains to intellectual property for discoveries to inventors and to authors. So it goes right back to the foundations of our nation. I think Juan, you went over this already about what is a patent, just to kind of refresh. It's an exclusionary right. It excludes others from not only making it, but using it, selling it, importing it, offering for sale. So it covers a lot of ground in terms of stopping others, right? So that's the right that you get, to stop others from doing all these things. Juan already covered it. This is sort of a refresher. There's 3 different types of patent protections. One for design, the way it looks, a plant, or something that is utility, that has a function of sort, right? And these are the times that it lasts, right? 15 years, 20 years, and then 20 years for plant and utility. This is a game. We're going to play a little game, but we're going to play an abridged version of that since we're a little bit short on time. The USPTO has a really cool activity called Spot the Invention. And we're going to look at a room, a living room in this case, and these little dots represent the different things in the room, and each of them is connected to a invention and a patent. All right. And so if I click on one of them, for example, let's click on this, the laptop. It takes me to the actual drawing for a patent for a laptop. And on the side of the screen, it gives me, I can look at the front page. That's a 3-layered laptop computer. It tells me the date, the patent number. I can go to the drawings and I could see the different drawings. I could see the specifications, which are the detailed description that the inventor has to tell us and disclose, so that patent examiners like Calvin and Juan and others at the U.S. Patent and Trademark Office can review to ensure that it meets the criteria for patentability. And then you'll hear about claims. Juan and Calvin are experts in this area because they either are or have been patent examiners, and they look very, very closely at the claim language that is found at the end of each patent. So in lieu of time, I'm gonna give you this link, and there are different rooms. I'm gonna put this in the chat box, and I encourage and invite you to take a look at this page and learn about all the patents that are all around you. Okay. All right. And we're going to skip this one. I think we went through this already. This is a little interesting one. The Statue of Liberty has a design patent. Of course, now that's been expired because this was given to us by the French, and it only lasts for 15 years from the date of issue. But it protects new and non-obvious ornamental aspects of products. The car manufacturers oftentimes secure design patents on just the way the cars, the shape of the cars, and so that they can protect these beautiful designs for new cars. We talked about plant patents, lots of really great examples. Apples, avocado, you saw earlier, Juan, the Haas avocado was an invention. It was a plant patent. The peach, there are peach variations. Honeycrisp, which is a trademark for the Honeycrisp, was actually invented at the University of Minnesota. So next time you bite into the Honeycrisp apple, think patent. Cool. My background is not biology, but there are a lot of different ways to create a new plant of sorts. Grafting is one of the mechanisms. For those of you out there who like biology and botany, you can study this. Maybe there's an interest in developing new plants. So those are the three different types of intellectual property, or I should say patents, utility patents, or different types of patents, I'm sorry. And then under utility, there's subcategories, if you will. The utility patents, as Juan mentioned, are the most common type of patents. So when you hear patents, you're probably talking about utility patents. And there are underneath this utility patent, which again protects how an invention works, functions, or is made, right? You could either have a process for doing something or a method. So for example, CRISPR, you've heard of CRISPR technology, which manipulates DNA to do some really amazing things, and it's really going to advance the field of healthcare in the future. A machine like a 3D printer, a Frisbee, an article of manufacture. Someone had to manufacture this. Now, Frisbee has a little R, and if you remember, R means that they registered this is a trademark. So it's a trademark, the Frisbee, but it's also protected by a patent, a utility patent. And then you hear a lot about, if you see television, you see a lot of new drugs on the market that are being advertised. So composition of matter, lots of different drugs out there. And that's another way to that manufacturers can get protection for all the research and development that they do in developing those new drugs that helps out save lives. Okay, I'm going to pass it to my colleague Calvin Hewitt, who's a supervising patent examiner, and boy, you guys are in for a treat. He is an expert in e-commerce security and financial technology, and is gonna wow us with a lot of really real cool things about cutting edge technology and things that I think you will be very, very interested in. So Calvin, take it away.
Thank you very much. We'll probably get into that later. So quick background, my name is again Calvin Hewitt, and I supervise patent examination in the business methods area, and specifically applications directed to digital rights management, e-commerce security, and financial technology. Next slide, please. So as Juan and Jorge discussed, there are 3 requirements for utility patent: new, useful, and non-obvious. Next slide, please. So here's something interesting, right? So the frozen confectionery. So since we're talking about utility patents, what are some of, so if you look at it, if you've ever had a popsicle, it's a popsicle, the ice cream, not the ice cream, but the icy on the stick. So when you look at it, if you kind of think about it for a second, why does this have utility? So you can write it in the chat, but in the interest of time, I'll just go. So one of the things you look at is that if you look at the image of the young lad with his with his little flower and his white collar, he's holding what? The popsicle. So the utility is, imagine if he held it, the icy, in his hand. It would melt, right? Because of the heat from your hand. He would have to, wipe his hand. He probably, wipe his beautiful white collar. So the utility here is that it allows you to eat something very cold without making a mess, right? And next slide, please. The healing apparatus. So this is interesting also because what is the utility here? So fun and games. So what's funny is that when you look at this, I remember a couple of years ago, this was all the rage. So the kids, skidding everywhere. And actually, when I looked at it in terms of utility, it could also be competitive. So I was always surprised when I looked at it. I was like, man, I'm surprised, because the Olympics just passed, that why this didn't get as big as skateboarding or snowboarding. And because one of the things that it has, the difference between this and a skateboard, you couldn't go into a mall and go into your home and skateboard. I mean, of course you could, right? But this allowed you to sort of bring that activity indoors. So that was its utility. At least that's, we could all have our own, but that's how I saw it. So utility is very important. The little note, go ahead. So what does non-obvious mean? Different inventions can be put together to create something new, useful, and non-obvious, a little redundant there. But basically what it's saying is that new is that, wow, this has never been done before. But one of the things about patent examination is that a lot of things are just common. If you can remember the original video with Christiane, most things are not new, they're new combinations. And one of the questions we ask as patent examiners is that, is it an obvious combination of new things? Like, does it make sense? Like making something portable, right? Things of that nature, changing the color, right? So if you might have an electric car, someone says, oh, my electric car is pink, right? Well, it's just a color change. It's obvious to someone as a design choice to color the car, whatever color the car they want for the car. But a non-obvious might be taking something like some other power mechanism and combining with the car, said, hey, I wouldn't have thought, one of ordinary skills was mentioned earlier, would not have thought to take that power source and apply it in a car. Next slide, please. Quick knowledge check. Do you have to be an adult to apply for a patent? Yes or no? So we can just go right to it. I think we have a lot of good answers. We have enough answers here. So yes, the answer is false. Right? You do not have to be an adult to apply for a patent. Next slide, please. So here's the invention, again, the popsicle, right? So what type of intellectual property protect this invention? So if you kind of look at the slide for a second, it's not the actual, if you look at, can you go back to this, to the actual?
This one, Kevin?
Yeah. So take the time, look at it for a second, digest it. Yeah, you can go back to the. All right, well, let's go in the interest of time. Let's, go to the answer.
Well, the answer is A. It's a patent.
But the funny thing, I'm sorry, go ahead. But the funny thing with that is that when you look at it, that, yes, invention, but there are other IP, as was mentioned earlier, around it. So just like you might trademark the name popsicle. And also when I was growing up, there was this ice cream truck called Mr. Softy, and you would hear the jingle, right? So maybe if Popsicle thought about the makers of the popsicles, that maybe we can create, if I sold it on the street, or sold it on the corner, sold it something, I'd have a little song that you would identify with my selling of the popsicle. So if you look it up, it's a guy named Mr. Softy, he used to drive around New York City, he had this classic tune, And that was actually a copyright case. So you could actually, if you think creative for a minute, yes, that invention is protected by a patent because the manufacturing process, right? Like, for example, if you kind of think about it, if the ice cream, if the icy was too cold, when the person put it in your mouth, it hurt your tongue. Like, I'm hurt. On the other hand, if it's not the right temperature, then it would melt and you person wouldn't enjoy it. So, so patent, trademark, copyright. So that part might be a trade secret. So yes, the patent is covered. So yes, the popsicle is covered by the patent as seen by this figure, but other IP could come into play. Next question, please. Are you allowed to study patents to get ideas to create in new and different inventions? Yes or no, true or false? So again, this was something that was, discussed earlier, and the answer is
True.
true. Facts. Yes, this is true. Next slide, please. Now, many of you have came up with your invention, so you kind of want to think of, now that you know that you can have a design patent, you can have a plant patent, or a utility patent. So from your invention that you came up with, which category would you put it in? People able to enter the answers? Because I remember I answered one question about what is intellectual property. I wrote mental real estate, and nothing popped up. I didn't see it pop up on the screen.
Okay, so I think I turned off
There you go.
that it could go, and you could, if you like someone's response, you could put the little heart. You can click on the little heart. There we go.
Okay. Yes, as one mentioned earlier, most likely it will, if you're filing for a patent, most likely it will be a utility patent. That's what, when people think of patents, that's what comes to mind. So, yes, well, thank you very much for sharing. And next slide, please. Turn it over to Joyce.
Are you able to hear me now? Okay.
Yes.
Wonderful. Okay, I'm Joyce Ward. I serve as the Director of the Office of Education at USPTO. And I'm going to talk to you a little bit about trademark protection. In my former life, I was a trademark examiner at USPTO. And in the short video that you watched earlier, you learned that trademarks can be just about anything. And there are two main things that they do. One, they identify, and two, they distinguish. They identify and distinguish the source. That is where a particular product or service came from, who made it, who's responsible. And Calvin just gave you a wonderful example there about the Mr. Softy smoothie. Next slide. So what would happen if we didn't have trademarks? Why are they important? So I want you to just take a quick look at these two images here and tell me, what is that on the left? And you can put it in the chat. You can tell me what that is. And what kind of beverage is that on the right? And you could just drop it in the chat. Okay. So just in terms of that, we don't know what they are, right? Because there's not any branding on these two products. So that tube on the right might be toothpaste, but it could also be wart cream. And what if you made a mistake? That would not be good on your toothbrush. Same thing on the right. It could be, let's see, it could be orange juice, but it could be beet juice, and I don't like beet juice. So I'd want to know what it is. The thing about trademarks, it tells you not only what the product is, but it also tells you the brand. So I would know that it was a particular brand of toothpaste, like Crest or Colgate, if it had a trademark on it. And that would tell me something about it, where it came from. The beverage, the same thing. If I saw Sunkissed on it versus, I don't know, Bertha's beet juice, then that would give me a different idea. Next slide. So the power of trademarks, just in terms of inventions, we've talked a lot about patents and invention, but you heard Mr. Calvin and also Mr. Juan and Mr. Jorge talk about the importance of branding with that video. The invention is great, it's wonderful. How are you gonna let the world know about it? How are you gonna let the world know that you're responsible for this wonderful invention versus something that breaks whenever you pick it up? You do that by branding, and that's where trademarks have tremendous value in terms of identifying the source of your product and distinguishing the source of that product from others. So the two really work together, as do all forms of intellectual property. And it also generates, as you see, the invention plus the branding, it also generates goodwill and support. And that's what makes consumers want to buy your product or to engage with you or to look to see what you're doing next. So when you combine all of these various tools of intellectual property or different types of intellectual property, it helps guarantee success. And just in terms of some examples of trademarks, trademarks can be anything. They can be words, they can be designs, and so on the left there, you see the trademark, you see the word mark, and then on the right, you see the design that's used with it. So Starbucks, a lot of people are familiar with that mark, as well as Nike, and of course that Target bullseye as well. So those are just some examples. So you can use words, you can also use symbols, but there are also other things that can function as trademarks. For example, if you can put in the chat, if you know what that little box with the ribbon is, that robin's egg blue box with the ribbon, how many of you recognize that or know what company is associated with that particular trademark? So believe it or not, colors and packaging, the look and feel of packaging can also serve as a trademark to identify the source. UPS is another one. Let brown work for you. And then of course the green and yellow of John Deere farming equipment. Next slide. Other non-traditional trademarks include scents. So there on the far left, you have an example of a fuel additive that actually smells like grapes. And you may be thinking, why on earth would someone want to do that? But what the trademark does is, again, remember, it identifies and it distinguishes. So if you're at the racing track and you smell that grape, you know that you have the correct fuel additive in your car. Verizon is another example with the scent that you smell when you walk into a Verizon store. They've actually registered that scent as a trademark. And then Play-Doh, the scent of Play-Doh. Who doesn't know the scent of Play-Doh? And so all three of these are examples of scent marks. Another interesting one that I found recently is a bowling ball that smells like mint, which is interesting. Next slide. And other non-traditional trademarks include sounds, such as the laugh of the Pillsbury Doughboy or the NBC chimes, doom, 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 or the spinning image here as well is another example of sounds. And who can tell me that sound that's associated with that third image there? I think this is another one where Dr. V is going to give a prize, so I'm not going to reveal that. I'm going to let people put it in the chat and we'll see what that one is. Go on to the next slide. Trade dress is another way that, another thing that can be associated with trademarks. So for instance, the way a particular store looks or a particular item looks are a present. So the Apple Store is a good example of trade dress. It's a really good example of trade dress. With the Coca-Cola bottle, the shape of the bottle can function as a trademark, as well as with Hershey's Kiss, the packaging and the little plume of the Hershey's Kiss, and of course the Timberland boots as well. Next slide. And I'm going to turn things over to Chris Dulce.
Hi, everyone. Thank you, Joyce. So now we are going to talk a little bit about copyrights and trade secrets. Sorry, my name is Chris Dulce. I work in the Office of Education at USPTO as well, with so under Joyce and with Jorge and Juan, and working with Calvin and Kathy on this presentation and the project. Copyright is a little bit different from both patents and trademarks. The best way I would say to distinguish copyrights is that it is an original work of authorship, such as artwork, writing, plays, or shows. So when you think of, say, paintings or movies, books, those types of original works of authorship would all fall under copyright. And the important thing also to remember about copyright is that it has to be made into a tangible medium. And I'll talk a little bit more about that, but essentially, just like with patents, you have to make it real. It's the same with copyrights. You actually have to, it can't just be an idea in your head. It has to be something that you put out into the world, whether that's on paper, whether it's a recording, or whether it's in a book or on film, something like that. So again, some things that are protected by copyrights include songs, books, movies, sculptures, TV shows, comic books, anything that you can think of, things that kind of come to mind when you think of art, are mostly covered by copyright. Next slide. Again, so including literary, dramatic, musical, artistic, and other works fixed in a tangible medium. Like I said, it has to be real. It can't just live up here in your head. It has to be put out into the world. One difference with copyright is that that is not something that is generally covered by our office. We do provide some guidance on copyright, but the Copyright Office itself is actually housed within the Library of Congress. So they're the ones that administer registration. Okay, so another thing that's a little bit different with copyright is that you automatically get a protection of sorts, a copyright protection, as soon as you put your idea into that fixed medium that I talked about. That is your property. That is essentially your protection right there. It is automatically created as soon as you make that work real. You do not have to register it or publish it necessarily, but there are some advantages. So you may want to actually register your works with the Library of Congress if you say needed or wanted to protect it in court, for example. Next slide. Okay, any questions so far on copyright? I know that was a little bit fast. But it seems like you all are keeping up great with it. So if not, I can get over. Okay, so a copyright is Similar to a patent or trademark, it is a type of intellectual property protection that covers generally like artistic works or works of authorship. So again, like think books, movies, paintings, drawings, sculpture, comic books, things like that. Does that make sense? And one difference, oh, sorry, I forgot to mention this. One other difference with copyright is that though it is covered for a duration of the life of the author plus, is it 70 years, 75? I think it's 70, but correct me if I'm wrong on that, anyone. But yeah, so essentially it's as long as the author, the original creator of that work is alive, they have copyright protection. And then their estate or their family or their whoever, their company or such would have those rights then extending for another 70 years past their life. Okay, so we'll move on to trade secrets. Trade secrets are one of the easiest probably for you to remember because it's right there in the name. The best way to protect any kind of trade secret is to keep it a secret. You are not going to disclose your information like you will with a patent, with a copyright, with a trademark. You're not federally registering it or registering it anywhere. The whole point of a trade secret is that only you know how to do the thing that you're doing. So some very common examples are Coca-Cola. They have a very unique formula for their syrup, right? And I think there's only like 2 people in the entire world that actually know what that exact formula is, and they have access to it. So even people that work in the company don't have access to that formula. Others are, and can you think of any others? Are there any other things that you can think of that are big trade secrets that they could be ingredients or they could be other things? Can you put into the chat real quick? Okay, so Ahan, I see how KFC is cooked, so that you are very, very close on that. Definitely KFC, but it's actually their recipe, their original recipe for their chicken. It's is it 11 herbs and spices? They have that special recipe for their chicken that only they know about. I see Google search algorithm. That's a great one. Some trading algorithms. Okay. Yeah. Yeah, 11 herbs and spices. I know that, well, we'll probably have it up in the slide. So if we can go to the next slide. Dr. V's getting hungry. So again, as I said, it is information, including could be formulas, patterns, recipes, compilations, programs, techniques, and that it has to be used usually in business in order to get an advantage over another competitor. So, for example, McDonald's secret sauce, right? They don't want Burger King to know what that secret sauce is because it's one of the things that draws people into the Big Mac. So that's another example of a trade secret. It's something that only they know, and they want to protect that from other people. They don't want other people to know what that recipe is. Next slide. So why are they useful? So they protect commercially valuable proprietary information. So again, like those recipes, formulas, algorithms. I like that Google algorithm example. That give you an advantage over your competitors, and you just don't want your competitors to know what it is, right? The thing that makes Google's algorithm so good, they don't want you, Yahoo, to know. I don't even know if Yahoo still has a search engine, but some of those other search engines, they don't want them to know what that algorithm is, because they know they've got such a strong one. Bing, thank you. That's another algorithm. Thank you, Dr. V. Okay, So there's no set, and lastly, yeah, there's no set term for protection. And there's no formal protection on it like there are with patents, like there are with trademarks, and like there are with copyrights. Your ability to protect it is just completely dependent on your ability as an individual or as a company to keep it secret, to keep it hidden from anyone else, especially your competitors. All right, next. How to lose a trade secret. Failure to take adequate steps to prevent disclosure. So I gave you that example of Coca-Cola, how there's only a couple people in the entire company that actually have access to the formula. If they just started giving that formula out to all their employees, that would probably not be an adequate step, because then any employee could go out and sell it. And that actually happened, I believe, with one employee years ago that was trying to sell. They got access to that formula and actually tried to sell it to Pepsi. They were one of the Coca-Cola's major competitors, but the folks at Pepsi actually declined because for ethical reasons they didn't want to accept a stolen recipe. So again, yeah, it's based entirely on your ability to keep it secret, to keep it hidden from others, and to protect it through those channels, those secrets that you keep in-house. Okay, so just another example, Krispy Kreme Donuts has a trade secret on their donut. Good, I think I covered that for the most part, so we can go to the next slide. So patents and trade secrets are really different sides of the same coin. So Dr. V, Mr. Wan, and Mr. Calvin talked about utility patents. They last 20 years from the time that they are filed. You must disclose your information. You must disclose your invention, your patent, in order to obtain a patent. With trade secrets, it's the exact opposite. You don't want to disclose anything. You just want to keep it secret and don't tell anyone. Good. Any questions so far on that? So one way that people could, just to quickly highlight, but one way that people can try to get your ideas if they're able to reverse engineer it. So there have been people that have been able to essentially take the McDonald's secret sauce recipe because through experimentation, they were able to actually figure out what some of the ingredients are. Okay, we can go to the next slide. Okay, so we have a little quiz, another quiz for you. Match the product to the form of intellectual property protection. So this is going to include patents, trademarks, copyrights, and trade secrets. So you should see 4 words there and 4 images. So you're going to match the images with words. And take a minute. How are we looking, Dr. V? All right. Okay, let's see those results. Amrutha, Ahan, Abdullah, all 4 for 4. Very well done. Okay, Joyce, great job. Abdullah. Okay, yeah, so some of these there could be some overlap, right? But generally speaking, the phone itself is a patent, right? That's and probably a utility patent, though there are also design patents on things like the casing for an iPhone. But again, the ingredients of Coca-Cola, trade secret. Music, anything that's, music, albums, soundtracks, things like that would all fall under copyright. And then McDonald's, you see the golden arches and the slogan, "I'm loving it." Those are both trademarks. And there's probably a trademark for having the logo and the slogan underneath it. I would guess. I don't know for sure, but okay, next slide. Okay, so I think we're on teacher mode still, Dr. V. Which type of intellectual property would Apple use to protect the iPhone 13? So there's a picture of it. Thank you. So what type of intellectual property would Apple use to protect the iPhone 13? And is it just one answer on this one, Dr. V, or is this a multiple choice or multiple answer possibility? Oh, I see. Never mind. So there's an option for either all of the above. There's trade secrets, copyrights, trademarks, and patents. Give you a minute. Okay, 5, 4, 3, 2, 1. All right, Ahan, we got A. Jane said E, all of the above. Abdullah said E, all of the above. Amrutha said C. Joyce said E, all of the above. And the correct answer, let's see. Does it say the correct answer? Actually, I'm not sure. It's E, all of the above. Okay. Good, right. So one specific device may have all kinds of things, right? So Apple has trademarks on the word Apple on their, yeah, the name if they have a logo or slogan. They definitely have patents on aspects of the phone itself. There could be copyrights in terms of, say, algorithms or software, potentially, and then trade secrets, things that they don't want others to know about. So good. From this point, I will go ahead and pass it back over to Calvin. Thank you, everyone.
Once again, next slide. Improve. So here's an example of some of the IP we found that you found around you. So we can go to the next slide. So provide an example of elements in this phone. So basically, okay. So if you click on it, like each one will be a column, and then just match the item on the left with its IP.
So, Calvin, so for the audience, you click on any one of these examples, and then you sort of drag them where you think they belong in what category of intellectual property. So for the instruction manual, does it belong under patents, trademarks, copyrights, or trade secrets? I'll take a couple minutes for you guys to kind of think about that.
All right, can we see the answers? Can we see the people's progress? Or?
Yeah, I think what we can do is have the students tell us. I think they're still in progress.
Okay.
Abdullah has finished. Several other students are still working on it. Abdullah, can you unmute? Would you like to kind of share what?
Oh, sure, no problem. Just looking at it, I thought that there's a lot of ways you can have patents and trade secrets. So I'll just start with my trade secrets. Okay, just to make sure everybody can hear me properly, right?
Yes.
Yes.
Okay.
Yes.
So starting with trade secrets, touchscreen, software code, and antennas can be trade secrets because due to like them also having patents, you might not know how they're built or how they're able to make them as efficient as they are. And that also goes with battery controllers, semiconductors. And advertising costs, I was kind of vague on that one. I wasn't sure. But that can be a trade secret to cover up how much they pay to advertise. And then suppliers lists also would be a trade secret to prevent other competitors from seeing who they're supplied by.
Okay, Abdullah, I have a question for you.
Yes.
Why did you put software code with patents and also under copyright?
All right. The reason I did that is because the software code, since it's like usually hidden unless you're part of the team, it would be a trade secret because the things like algorithms and programs, for example, like the Google search engine, that is a very powerful trade secret, but also Google might patent their technology or the techniques they use in order to prevent others from using it. But not as, for example, like they wouldn't patent the entire idea of a search engine, but just the specifics that they would use, the specific techniques.
Right, and that's the little thing. Oftentimes in common parlance, you will hear patent software is patent. They put the two together, but actually software is covered by copyright. But how the software, when executed, runs on a machine, that is covered by the patent.
Okay. There's a,
okay. So go ahead.
And also just for the trademarks, I kind of didn't see many, I think, but the Apple logo and the name, like those are some prominent trademarks because I think the name would also fall under copyrights if I'm not wrong, because they could, I'm not sure if they could or could not, but the logo is a trademark for sure.
Okay, well, thank you very much. Thank you very much. Next slide. So yes, here, as Abdullah pointed out, for example, on trademarks, you have the logo. Under patents, you have the chip or the touch screen. Copyrights, you have the code. The trade secret wouldn't be a secret, right? If you knew what it was. And some designs, for example, the shape of the iPhone and like the gloss of the finish. Next page, please.
Calvin, we have a question. Can you have a copyright on a program?
Yeah, that's considered software. Because in essence, if you think about it, it's when we say it's covered by copyright, it's the actual. If you think about it, when you write code, it's actually in written form, right? It's a list. It's a list, and that is in essence was covered by the copyright, because in essence, it's like a work of art, right? Right? Because it's funny because one of the things you can look at, people who are coders and hackers and whatnot, they would look and say, well, I can tell who wrote this code by the design, by the things that they use. So yes, the software, the written code is covered by copyright. So the patent application journey. So first you need an idea. So is your idea worth protecting? So first I'd like to say that I have a lot of respect and admiration for those who file for patents, right? Particularly like small inventors, because it's like standing on stage, right? There's a good chance you might get booed. In other words, in our world, you might get rejected, right? So it requires a certain amount of confidence. And if you listen when Jorge was talking, when Dr. B was talking, he was discussing the process about fail fast. And what's the other, what is it? Fail fast and fail what?
Forward.
Fail forward, fall forward, right? Fall forward. But so there's that possibility of failure. So a lot of times, what you find in the applicant, there is a confidence. And if you kind of just, when you flip it for a second, you also think about how much was lost, how much innovation was lost because people lacked confidence, right? So is your idea worth protecting? Yes, but, right? But ask yourself the important questions. What is the proper IP protection I'm seeking? If I have a jingle, right, like the Netflix sound, I'm not gonna get a patent for that, right? So you have to get the right, and also apprise yourself of the work that's out there, what has been done already, right? Also, learn about the law. So these are the things you have to put in going in, but have the I'm encouraging students out there, lean in, don't kind of pull back, say, I don't know, put yourself out there a little bit. Next slide, please. So how does one get an idea for invention? So we've heard a couple examples. Put some ideas in the chat, or you can put it in a little text tool. And Jorge, did you turn the switch so that we can see what people are writing?
Yeah, let's see. Approved students is it should be globally. I guess at every one of them it says so as the students are putting in some of this, I propose we take a quick 5-minute break and we reconvene at 11:25. Just a quick health break. And but feel free to continue to add to this post. And we'll reconvene at 11:25. Okay. Is that okay, Colin? Can we do that? Awesome. All right. Okay, it's 11:25 on the East Coast, and here in New Jersey, it is snowing heavily. How about where you are, Calvin? Are you
Oh
getting
yeah,
snow?
it's snowing. It's one of those
Yeah.
like sort of annoying snows. It's like it's like hanging out on the trees, on the
Oh, yeah.
grass. But, you know, as long as it's not on the ground, because you know it's not enough. If it gets really cold, then it would freeze up on the ground, and that's never fun for anyone. So right
Yeah.
now it's kind of annoying. So hopefully it'll get warmer during the day, so it might go away. But right now it's just on the trees, just on the grass, and there's really nothing on the street or on the sidewalks.
So we have some good input from the students on where does one, you know, find that idea for an invention. Several students wrote problems, finding solutions to problems, looking for issues, and being inspired by other things that have been invented previously. And I love Tala's comment about, you know, being passionate. I think his passion really drives. Inventing is not easy. You know, coming up with an idea and carrying it all the way through to fruition and to actually, you know, create an invention is not easy. You have to put a lot of hard work into it. So you have to be passionate. If you're not passionate, you're not going to get, you know, all the way to sort of the finish line. So really a lot of great input here from
And
students.
what's funny, we had talked about earlier, is that what I didn't see is when all those years ago when I was a kid, like in the 70s, right? They had the PSAs for Schoolhouse Rock.
Yes, I remember that.
Right, and they would say, I have it written down, and one was mother necessity.
Yes.
And it was because necessity is mother invention. And like the ending, it said, read it, with mother necessity, where would we be without the inventions of your progeny? So I think, you know, I think we need to get back to that a little bit, the PSA. But, you know, that was when, you know, for me, because, you know, that trademark, that copyright, that jingle is all in my head. And that's the first thing I think of, mother necessity, mother necessity, mother necessity.
Indeed, indeed. Okay.
Say, you know, basically what you learned from this little clip about Philo Farnsworth. Did you activate it? Can they type in? So real quick, so one of the things that's interesting is that that's not a unique story, right? Like there's Granville T. Woods versus Thomas Edison, Edwin Armstrong versus the aforementioned David Sarnoff, Nikola Tesla versus Edison again, and then there's Robert Kearns versus Ford and Chrysler. So a lot of times when you're this innovator, you know, and you sometimes will get put against or pitted against this big entity, this large corporation, right? These huge money interests. And what the patent does actually is sort of levels the playing field. And so just as Philo Farnsworth ran into trouble with David Sarnoff and RCA, you have Granville T. Woods, who defeated Edison in court. And before that, and not all of these large interests, these large entities are as adversarial. So as was mentioned earlier in one of the earlier slides about Alexander Graham Bell, when I think it was President Rutherford B. Hayes said, you know, it's cool, but who would ever use it? People questioned it. One of the things that Granville Woods invented was he came up with a system that allowed for improved long distance call quality. So instead of, so it's not always adversarial, so Bell just bought his patents, right? And so it's not all, it's adversarial, just as a, you know, I don't examine anymore, I'm a supervisor, but that is an adversarial system between examiner and inventor. It's also between when you have your patent, between patent holders or between someone with the patent, someone without. That's just the nature of the system. But if you're interested in that, if you're interested in this sort of story, this sort of dynamic, there's a really good book by Tim Wu called The Master Switch, another one by Walter Isaacson called The Innovators. And it talks about this trend, this this technology, sometimes new versus old, and large and small. And they're really good books, and they're good reads, and they're very readable, but they kind of build on the story that you just learned about between David Sarnoff and Philo Farnsworth. Next slide, please. Oh, it's dead again?
Basketball is back. Stream the action live. Are you tired of your wet dog leaving smelly wet spots on your furniture? Do you want to eliminate the aggravations of your wet dog racing through the house, shaking water and everything, or worse yet, rolling outside in the dirt? Do you avoid hugging your dog until they're fully dry? Introducing the Puff and Fluff. The Puff and Fluff is revolutionizing the dog drying process. It's simple, it's easy, it's fast, and it's safe. Gone are the days of confining your pet or leaving them alone for hours to dry. That damp dog smell is now gone within minutes. From a third grade school science project called Invention Convention, and with the love for her pet pug mojo, Marissa Strang set out to find a better way to dry her dog. The goal? Dry your pets fast before they have a chance to run away and cause trouble. Here's how it works. After bathing your dog, towel dry any excess water from your pet. Locate the head and tail markings on the Puff and Fluff and place your dog appropriately on top of it. Reach underneath and pull your dog's paws through the leg hole openings. Then simply grab both sides of the Puff and Fluff, bring together, and attach the Velcro. Lightly tighten the drawstrings around your dog's neck and tail. No need to over-tighten. Air should be able to flow through the openings. Attach virtually any blow dryer to the flex hose and turn your dryer on warm or low heat using the high-speed setting. Dogs love the circulating warm air. The Puff and Fluff not only calms your dog, but makes your dog fluffier too. After a few minutes, loosen the drawstring on the neck or tail and reach in to feel the air. Make sure the temperature is not too hot. You can also check to see if your dog is completely dry. Now, the hours of dry time are accomplished in just minutes at an affordable price.
My dog loves the warm air, and I like giving him a bath now. No more wet, smelly dogs with the Puff and Fluff.
I love the Puff and Fluff. For more information, go to www.puffandfluff.com or call now at 1-855-783-3583. That's 1-855-PUFF-FLUFF.
Yes, so what problem was Melissa trying to solve with her patented invention? Does anyone have, yeah, and if anyone has dogs, it should jump right out at you. So we had a dog, like, so our dog had passed, but we have two new ones now. But oldest one, Coco, was a Bernese Mountain Dog, and she hated the sound of the dryer. So we were like, man, how do we do it? So we have to, hug her, and dry her. So drying a wet dog is a challenge. So is your idea eligible for protection? Again, like when I was saying earlier, is it worth it? Check it out. But at the same time, be thoughtful about it. So if your idea does not fit into either a process, a machine, an article of manufacture, or composition of matter, then it lacks utility. So it should fit in one of these 4 boxes. Next slide, please. So this gets to the child-adult thing, right? So who can be an inventor on a patent? Anyone who contributes to the conception of an invention. Next slide, please. The patent application journey. Present your idea. Maintain confidentiality. Next slide. So now that you said, hey, I have an idea, I've done my homework, I've done my due diligence, I've researched, I've found other people who do it similarly. I've tried to understand the law and where my invention lies. Is it a design patent? Is it a utility patent? Whatever. And I've kind of thought about my idea a little bit. Now I'm going to draft the application. Next slide, please. And ultimately file. So, but real quick, so what do I need to disclose? A patent is, as Juan mentioned earlier, it is a quid pro quo, right? If you want to keep it to yourself, then you should think about a trade secret. But when you file the patent, in exchange for the right to exclude others from making it, from using, importing, or selling your invention, otherwise using your invention for a limited amount of time, you must fully disclose it, right? You can't sort of hide the ball. So a patent is a public disclosure because, as we've learned earlier, people can learn from patents. It's about putting knowledge forward, right? But in the right to, and that's so interesting when you think about it, because a patent is actually a monopoly, right? So in return for your adding to the body of knowledge, right? And in terms of patents, of invention, in return, you get a monopoly. So that's sort of the thing when Jefferson sort of devised the system, that's what he understood, that people will not seek patents if it's not gonna be profitable. But at the same time, you do owe something to the public, right? Because, this country was formed, and therefore, since you're able to exist in this country and it's given you the technology, the trees and everything else, better for worse, right? The schools and everything, well, you owe something back. And that's sort of that marrying of those ideas of self-interest versus public good is embodied in the patent system. Next slide, please. And then ultimately you file your application. And then it comes to us and we look at it. Next slide. Back to Juan.
All right, thank you, Calvin. So the path to a patent, we've talked about this before. Everything starts with an idea, but you got to do something with the idea. So once you've taken that idea and you've stewed on it a bit, you've mulled it over, maybe you've designed it on paper, on a CAD system, maybe you've developed a prototype, you've built it. Now you want to file for protection. So there's a couple different ways that you can go about it. There's one patent application, right? We call that a non-provisional application. That's when you're ready to go and you want to get protection. You have all the information in place, all your structure and everything you need. You can start right away and go right into the non-provisional application. Or you can, if you're not quite ready, you have everything, most of the invention ready, you're just not quite ready to file yet, you can give yourself some extra time and file yourself what's called a non-provisional or a provisional application for patent. It's not a patent application. Basically, you just file all the information and you give yourself a hold. You give yourself a 1-year hold. The date you filed that provisional application for patent is starts at clock, right? And you get that filing date. So if that was today, what's today? March, what are we? March 12th, right? You gave yourself a year from this date to actually come in and file the non-provisional application. Maybe you need to talk to a lawyer, or maybe you're still kind of working out patent drawings and you want to get the drawings straight and you still need some time, but you want to give yourself a filing date. That's when those types of things are when these provisional applications for patents go. Maybe you're going to do a science fair presentation. You're going to publicly disclose information about your patent, but you want to give yourself some protection. You're also you can use this provisional application pathway to give yourself a little extra cushion before you actually file. Now, notice once you file that non-provisional application, that's when the clock starts ticking on the 20-year protection that you will receive eventually should your application convert into an issued patent, right? So once you get that patent, the patent is valid for 20 years from the date of first filing, right? And so that filing date could be the provisional application date if you have a provisional application for patent, or it could be the non-provisional date, depending on there. So that's the quick and dirty way to path to a patent. Next slide. So Once you get a patent, you'll receive this really cool certificate. It's signed by the undersecretary, the director of the patent office. It's pretty cool. You will save this document for the rest of your life because that's your invention. No one can take that away from you. And next slide. Right now we're gonna talk about the different things you're gonna see on a patent cover. This is the cover of a patent document. It has a lot of information packed into a single page right now that I'm going to talk about real quick. And hold on a second. I'm gonna tell my son to hold on, give me 5 minutes and I'll talk to you, all right? All right, thank you. So on top of a patent, we have in the top right, it's called the issue date. That's the date the patent publishes. It's officially live for the public to view, and the world is told that, hey, this is so-and-so's patent, and it was filed on this date. Next, we have the invention title, which is in the top left. Now, those titles, notice the title. It's very plain on this. It says computer system. So imagine you had a brand name for your computer, such as, a MacBook Pro or something like that, right? Well, you're not going to put that brand name on the patent. The patent title is very generic. It's very just generically describes what it is, a computer system, right? And so then the name of the inventor is actually on your patent. So your name is going to go right on this cover. So everyone's going to see whose invention this is, right? And there's all kinds of things. There's an abstract, which is just a quick description, one paragraph that describes in general terms what your invention is, right? And there's a drawing. The patent examiner, after they decide to issue your patent, they're going to select the drawing that best describes what your invention is, as in terms of the claims. And the claims come at the end of the patent, and the claims are the most important actual part of the patent. Inside the patent, if you turn it over, there's going to be a written description, which is going to describe how to make and use your invention. There's going to be a brief summary of the prior art. What we call prior art is anything that was described in any printed publication before your filing date for your invention. So all kinds of information packed into this little front page of the patent here. Next slide. So these are patent claims. So this is, I talked about a claim at the end of the patent document. The couple of last pages are going to say claims. This is what, if you ever go to court, hopefully you should never go to court if you have a patent, but this is what judges and lawyers are going to really, really dissect and going to look at, because this describes your invention. This lays out the boundary, right? If you've ever owned a piece of property or land, you get what's called a deed. In that deed, it's marked out by a line, a border. Everything inside that border is your property. You own that. This is what the patent claim does. The patent claim language distinguishes and outlines that border. Everything within those just written, that description of the claim is what you're getting protection for. So in this example, we have a simple claim for a chair. It's a chair comprising a seat, a back support attached to the seat. Now notice, it starts at the top, and everything you add on underneath it, it adds further limitations to what came before it. And they have to talk to each other, work together. So a back support attached to the seat. So the seat came first. Now you're adding a back support. Next, we're going to add even further support arms attached to the seat, which was already claimed, and the back support, which was already claimed above. So now we have arms, a back support, and a seat. And then lastly, we have a base comprising a plurality of legs. So we have a base with lots of legs attached to what? The seat, which came all the way at the top. So you notice everything stems from that seat. So without the seat, the rest of the claim doesn't exist. So you start from the top and then you build your way out into what your invention is. Next slide. All right, so in terms of patents issued over time, this graph is a great example of how technology has advanced. So this chart represents every year how many patents were issued that particular year. So if you look from about 1790, which was when the patent office first started, to actually not the patent office, the patent system, to 1860, look at that. Each year there was hardly any patents issued compared to now. You start jumping exponentially, right? Technology starting to advance. And if you look at these years, I don't know if these slides, we have these slides, Dr. B, but if you look at these years, there's some jumps, there's some decreases, you know, and then all of a sudden, boom, towards the end here, about 1980, it starts jumping real high, right? And so you can associate different periods in history with the number of patents that are issued per year. So it's kind of cool to look at this. Next slide. And I think we're going to dissect it a little bit, maybe not. All right, we got a video.
It was the summer of 1787, and the Founding Fathers had gathered in Philadelphia to address an ambitious plan. George Washington presided over this constitutional convention, which made a number of far-reaching decisions that continue to guide our nation to this day. The framers had many disputes as to what the Constitution should contain. However, there was no dispute with respect to Article 1, Section 8, Clause 8, also known as the Patent and Copyright Clause. The Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. These simple yet remarkable words established the U.S. patent system, and in 1790, less than 2 years after the ratification of the Constitution, George Washington signed the first U.S. patent grant to Samuel Hopkins for an improvement in making potash and pearl ash. A patent is truly a significant document both for the inventor and the public which enjoys the benefit of the discovery. The patent provides the right to the inventor to exclude others from making, using, selling, or importing their invention without their permission. It also clearly reflects their creativity, their ingenuity, dedication, and hard work.
In the last 200 years, the patent cover has undergone over a dozen design changes, though in the last century, the design has only changed twice. We looked to a lot of the historic patent designs for inspiration, though I quickly realized there was not a lot of information out there, and we really had to turn over some rocks in order to gather enough examples for us to work from. Some of the best examples we found were from the 19th century. These were incredibly intricate, ornate documents from a bygone era. They looked like what you'd expect to see on currency or stock certificates, and the designs really conveyed the value of what they represented. Looking at these historic designs, it became clear that what we created would have to convey that same sense of value. A team of USPTO designers combined efforts to create the new patent cover. I asked each member of the team to design an improvement to the existing patent cover, a classic version inspired by some of the historical examples, and an anything-goes, clean sheet of paper approach. As designers, a lot of what we work on comes and goes very quickly. So to be able to work on something of such historical significance is a once-in-a-career opportunity. These patent covers will persist for generations in museum collections, in libraries, on the walls of an inventor's great-grandchild. That's something we're all very proud of.
Yeah, so that's really cool. Real quick, let us know what you took away from that video. What did you take away from that video? A lot of cool historical context that was shared by some of our colleagues here at the U.S. Patent and Trademark Office. So go ahead and let us know what some of the takeaways for you personally from that video. Go ahead and enter it there on your screen and share those with us. Or in the chat if you're not in the Nearpod. Is there anybody listening out there?
Can we just comment?
Sure. Hi, is that Nancy? How you doing?
Hey, yeah, hi. How are you all? Thank you so much for this extraordinary opportunity with our young students. I wanted to share with you something. I don't know if you can see this. Let me hold it up. Can you see it?
Yeah, it's a little with the background, but we see it. It's Pete's trading card. We love it.
Yeah, so this Pete Conrad has a patent. And so USPTO kindly made a Pete Conrad trading card. And who knows, someday you may be a trading card when you get your patent. And it's one of the big awards that we do with the Conrad Challenge, as you all probably know. And I just wanted to say how important it is to think about this and to understand the whole process, because this is like the crown jewel of innovation. And I was just pulling up a quote. This is kind of interesting. Let's see if I can quickly find it. Innovators are the ones whose dreams are clearer than the reality that tells them they're crazy. So I thought that was kind of interesting. That's Simon Sinek, who wrote a book about it. It's all about the why. Oh, thank you for pulling that up. Yes, so we presented this a couple of years ago, I think about 3 years ago, the last time we did our live summit at Kennedy Space Center. And we're very excited to have that as part of the portfolio of things that the Conrad Challenge holds. I'm not going to jump into too much of this, but I just wanted to say thank you to the team at USPTO for all your help with this effort and for helping our students to understand how important it is to protect your ideas and to, first of all, have the ideas and then to have the capacity and the ability to hopefully get a patent. And that's a process in and of itself. So, and hi to Joyce, I see you. Hi. So how do you like my new background, guys? Pretty cool, huh? So yeah, I'm just tickled silly that this is part of our portfolio and your portfolio, and we're just very, very grateful for all your help on this. So we're looking forward to seeing these finalists at Summit. We go live this year, hallelujah. And we're also doing a virtual showcase. So multiple opportunities for young people to really participate in what the future looks like. I'm not sure it looks like my screen drop, but we'll see what happens.
Thank you so much, Nancy.
Hey. Jorge. Hey.
Hi, Nancy. Good to see you, Nancy. Thanks for joining
And
us.
thank you to the Conrad Foundation and to the Conrad Challenge and to you, Nancy, for the vision and the passion that you bring to this work and for all that you do to celebrate and keep Pete Conrad's vision alive. We're very excited, or thrilled, I should say, about the addition of the Pete Conrad trading card, and just love the way that we see that reflection of your view in his eyes. Almost. So, thank you again.
Yeah, thank you, Joyce. It's a pleasure to work with you and the whole team at PTO. We've been connected for many years. And my good buddy, Jorge. Take it away, Jorge.
Hey, Nancy. All right. Moving on. So we wanted to show you on this journey to now over 10 million patents, right, that have been issued from, the United States Patent and Trademark Office, just to give you some examples along the way that we kind of picked and said, well, it might be interesting to share this with the students. This is Chester Greenwood, a 15-year-old inventor from Farmington, Maine, who invents the earmuff, right? And so he reportedly came up with the idea while ice skating. And what a great day, because it's snowing here in New Jersey. But while he was ice skating, he asked his grandmother to sew these tufts of fur between some loops of wire. And so his patent was actually for an improvement to ear protectors. He went on to manufacture these ear protectors and created jobs for people in the Farmington area for over 60 years. That was an interesting story here. This next one, well, the toilet paper in 1891, and my colleague Juan and I kind of kid around about this patent because it, Juan, maybe you can speak to it, but it shows you how the paper should be. Oh yeah, you can tell the story.
So the age-old debate that you may or may not had this conversation before, but you definitely will at some point in your life have a conversation on how toilet paper rolls should be hung in your bathroom. And so does the flap go on the outside or does it go on the inside? And I'm here to tell you today that the conversation's over. It's clear by the picture on the patent drawing for the very first toilet paper roll that the flap goes on the outside. All right. So don't let anyone tell you otherwise. Just find this picture and show them. The patent is the mic drop moment. There you go.
Thank you, Juan.
Can I interject something about that for a second?
Yes.
Our
Yes.
members of our board, her father has the IP on, you know, when you get the roll of toilet paper and the end of it kind of sticky, and you have to peel that little piece of paper back. He owns the IP on that. He's deceased, but he owns a whole lot of IP. And one of our directors, her father created that. How about them apples?
I love that, Nancy. That is so great because literally everything that you pick up in this world most likely is protected by some form of intellectual property. And so every time you finish a roll of toilet paper, that is exactly right. Like it sticks, you're pulling, you're trying to use every last sheet you can, right? And that stickiness, that was somebody's idea to do that, right? And they protected that. That is so cool to know. Thank you for sharing that.
Okay.
All right. The Coca-Cola bottle actually initially was a design patent for the shape of the bottle, and I think Joyce talked about that as when that patent expired, then the Coca-Cola company secured a trademark for the shape of that bottle, and it's still active today because, as we've heard earlier, trademarks don't, unlike patents, don't expire. You've all heard of the phrase, the best thing since sliced bread, right? Well, I got to tell you, this is a 1932 invention from Otto Rottweiler, who received a patent, 1 million something or something, for a machine for slicing an entire loaf of bread at a single operation. And if you go to the stores today, I shop at Wegmans, and they have this, the machine is the same machine that was invented way back when. The first applications of this bread slicing machine was actually in Davenport, Iowa, where, you know, people would come, customers would come in, and they were so happy to pay an extra penny or two just for the convenience of taking that loaf of bread home already pre-sliced so that they can make sandwiches and so forth. So that's an interesting story. That 1940, let's see, where are we now? 1940, the Walt Disney receives a U.S. patent for the art of animation, basically ushering in the modern animated motion pictures that many of us enjoy. Way before, I know everybody's time here, but crash dummies, Samuel Alderson in 1961 receives a U.S. patent for a human equivalent dummy. Okay, this crash test dummy helps greatly improve vehicle safety. So remember, next time you step into a car, remember to thank Samuel Alderson for helping make our cars safer. I'm going to pass it back to Kelvin.
Thank you very much. Next slide, please.
We're going to play a game. Guess that game.
Guess that game. So once again, you have 4 items, and you're going to try and match the description with the figure. So if you click on one, one figure, then you might click on the description that shows that they match, and you can go.
So it's quite a bit of reading. And try to, you know, there are 4 pictures, like Calvin said. You can click on the little bar on the bottom right, and you can then read.
And just so they know, Dr. V, what
Yes,
you're reading are actual patent claims.
Claims,
So
yes,
these
good.
are what's claimed on an actual patent that's defining the scope of their invention as you're reading this. So
thank you, Juan.
So take your time.
Hard to see.
So would you like to, in the interest of time, would you like to kind of go through them?
Well, let's see. We have, I think some of the students that have already responded have gotten most of them. But I'm happy to put them up if you want.
Yeah, sure.
And so what is this? think everybody knows what that is. You can put it in the chat box.
An ice tray.
Yeah, it looks like a bunch of ice cubes kind of put together. Hence the hint cube. There's our famous Barbie doll. There's a game that I'm not even sure I've ever played this, but
Twister.
Twister. And then this one, I used to have one of these. I love
the iPad.
The iPad.
The iPad.
But we won't go into the language here, but I think, the claims is something interesting for you to kind of think about, as Juan and Calvin have mentioned earlier. This is really where the rubber meets the road in terms of the protection for patents, and those words that are used in the claims are really important, and the way they are written, the words that are chosen, like the word comprising, the architecture of that language is critical, because that really defines not only the scope, but really what ultimately is protected and can stand up in a court of law should you find yourself in such a situation. All right, let's move on. I think we're gonna. Do we want to do the drawing, or do we want to skip this?
You might want to skip that.
Skip it. Yeah. We'll skip the mousetrap. Now we get to
in the real world.
The grand finale in the real world.
Okay. So next slide, please. So one of the things we're going to take a look at is, we had patents going back years, but we'll take a couple of moments to look at patents in this era, trying to solve issues with this era, problem solving this era. So this patent 10.977.583 is directed to scheduled temporary rental property access. That's a title, right? But what it describes is, let's say you have like a mobile device, you have your app, and what you're able to do is register in essence with a computer, with a server. And then after you register, for example, you want to rent an apartment or rent even a room for a certain amount of time, you basically sort of get like an electronic contract, for lack of a better term. And then in response, once it's authorized, you receive a digital key. They call it an electronic credential. Then when you go to the property, and when you say, okay, here I am, like they reckon that the sensor says, okay, yeah, Calvin's there. I then take my phone and I send the credential to the server. The server says, okay, this is valid, and then unlocks. And so this I'm not able, so, and what's interesting here is that the patent, as opposed to the claims, but the patent describes even within a home. So if you have been in a rental property, there's to get in, but then there are little rooms within. So you can basically have partitions to who can access which rooms and which parts of the house. Additionally, there's like a computer out there that controls the locks, it controls access to the thermostat and all these things basically through this app in your relationship to the phone, that little controller computer, and the server out there. So as if you think about today and renting properties, like here's a way that they're using cell phones, wireless technology, servers, a little bit Internet of Things to look at how people rent and occupy space in 2022. Next slide, please.
So Calvin, I know some hotels like the Marriott, the Westin, which is where I stay near campus. You can get the key, and you could unlock the door with that. Is that the same technology?
Well, it's similar technologies. Remember, inventions come down to the claims. Well, the difference here is that the server, what they're talking about is really, in essence, the partitioning. Right. Okay. And also that you have this device that controls like your interaction with your phone. It's about access. So it controls access to the refrigerator, controls access to the thermostat, controls access to the alarm. And then there are cameras and sensors all around that sort of tie all this together. So it's a little more detailed than that.
Okay. Thanks.
So this is another thing that's interesting. So here, in my day, when you turn on the television, you had to walk up to the television and you had to turn it, right? Then the remote control, we call it the power, like, oh, I got the power, right? But here's something like an advance on that idea is that you have, let's say your iPad, not, I don't say iPad, but your little pad, right? Your digital pad. And you can interact with not only your television, not only your appliances, but any sort of object in your home. But with this pad, with your pad device, what's interesting is that you don't actually have to touch it. You don't have to actually touch the screen. You can basically hover over the screen and you control things. So that's why it's, so that was very interesting. So again, here, instead of like the remote control, it adds on because it talks about how you can interact with the screen and using hand gestures without actually touching the screen, you can control objects. Next slide. So the term NFT is hot. And one of the things that's always as part of our job as patent examiners is that we search for prior art. And one of the things that's always so interesting is in that question, in that search, is how you find things that people say, oh, this is new. No. There's a good chance it might not be. So Martinez et al. So the NFT is a non-fungible token. And basically it's representation of like art, music, images, and the like. So what's fascinating is that if you go, so this patent was issued in 2000, what they came up with was this concept, and like now, like these NFTs are tradable. Well, again, in 2000, when this patent was issued, they had this idea of creating digital objects and then trading these digital objects. And there's also a certificate, which is cryptographically secured, associated with that digital object. And then you look here, you are in 2022, like NFTs are hot, NFTs are new. Well, actually, it's the concept in many ways is over 20 years old. But that's why before you start your journey, if you go back to those slides, take the time and trouble to look at what has already been done. That's why, because you might not get everything, that's why you file. But they take that time and trouble to investigate what has already been done. Next slide, please. Here's something interesting, right? So this one is basically what's happening is you have this car, unmanned vehicle running down the road. And as it's running down the road, the thinking is, how do I make a delivery? So you can sort of see the utility, right? So you can almost see cars like running around, flying around, going here and there. And let's say it made one delivery and now it's empty. So now it's going to another place. So if you think about the problem this solves is that whereas in the past, what did you have to do? After you dropped everything off, you went back to the depot, reloaded, and went back out. What this basically says is that, hey, you don't have to do that anymore. This unmanned vehicle never has to come back home. It can just start to go into the next location. But how do you refuel? How do you repackage it? Well, what they came up with was basically you have a drone which has the package. And while the car is en route to its next destination, it basically delivers it. So, it's this whole relationship, a matching process between the actual vehicle and the kind of vehicle it is and the drone, and then they adjust and it drops the package through the roof and closes and keeps going. So that's, again, mother necessity, but such an interesting problem. I was like, wow, that's so cool, right? Next slide, please. Okay, this is funny, right? So just as when, I think it was Juan that showed the slide of how the phone changed, how you went to, the staid, phone, with the heavy bass to like, the ring, that was Jorge, and a watch. Well, one of the things they talk about, you can monitor, you can use your phone, your ring, your watch, and you can monitor your progress as you're exercising. Well, this patent came out in 1974. What it is, it's a portable device that you would wear, like you wear your ring and you wear your watch, and it's programmable. So you can program your goals, your exercise goals. And then as you move, right, like each contact, it sort of tracks. And then it makes comparisons like, oh, you've achieved your goal, your exercise goal. And this is 1974. Ice ages ago, really long ago. But again, that's why you take the time and trouble to search and learn what has already been done. so that you can add on to the body of knowledge. But that's funny. You have the jogging computer. Good slide, Jorge. Person jogging with the computer. This is fascinating. So in 1966, there was a movie called Fantastic Voyage. And in Fantastic Voyage, what happened was they shrunk, there was some scientist was attacked. And so therefore they had to save them. So what they did was they took their ship and they shrunk it down to like a microscopic level. They inserted the ship with the people inside, and it basically they had to go. They it had conflict and they fought each other. But they basically went to his brain, got rid of the clot, and then they had to get out in enough time because obviously, if it gets really large again inside the human body, that's not a good thing because it was a ship. So basically, they came out through the tear duct, and it came back to life, and everyone was happy. But when I saw, I was like, wow, right? Since we don't have that ability to shrink people and shrink vehicles, how do you control, how do you navigate these, like an implantable device? Well, what they came up with is a means of using electromagnetism to navigate an implantable through the circulatory system. Like, fascinating stuff, right? But here it's interesting, is like, I don't like similar, like when you have the smartwatches, for those of us who remember Dick Tracy used to have his two-way wristwatch, right? So I don't know if the people that came up with this knew Fantastic Voyage, but you can find inspiration in many places. Comic books, cartoons, Star Trek is the famous one, or just in your experience in life, right? Like the pattern with the unmanned vehicle making deliveries and the drone, that was sort of a practical problem that's really only in existence today, right? And so, well, how do we solve that? So they came up with this idea of like, when it's moving, and then you put them together. All right, next slide. Yes, okay. So think about the Philo Farnsworth story, right? And it was kind of sad and dour. I was like, oh man, right? Kind of a buzzkill. But, right, the one-click patent describes that same sort of a dynamic relationship, but with a different ending. So here, patent 5960411 describes, so in many years ago, when you tried to buy something over the internet, you had to go through a lot of different screens and there's a lot of clicks. Man, I remember when I first, just forget the clicks, just the fact you were entering your credit card, I didn't know whether it would get there. And we're still dealing with the problem of, is it getting to who it's supposed to get to? But what's interesting is that when they came up with this patent, with this idea of how to make the shopping, technologically make the checkout experience more efficient, right? People thought it was such a good idea that they copied it, that they tried to use it. And in that case, it was Barnes & Noble. Barnes & Noble's was the old established company. Amazon was only a couple of years old. But because they had the patent, the court said, Amazon wins. And if you read the little quote, said, when we write the history of electronic commerce, the one-click patent allowed Amazon to create a very strong position in the market. They're now worth, I'm pretty sure, even though the market fluctuates, over $1 trillion. It's a $1 trillion company, in many ways off the strength of this one patent. And it's funny is that there's a timelessness to it also, because they didn't think about the mobile aspect. But there's certain advantages to using your laptop or using your desktop versus using your phone. So then just the fact that the single click on, basically assembling all the information you need and while you're going through a process so that you are able to do something in one click, right? It has a life, it has utility even beyond what people thought. And that's sometimes what happens. Next slide, please. So just as you've heard of Amazon, $1 trillion company, there's another company you might not have heard of called Intertrust. And their patent is 5892900. And there are others, but 5892900 is the main one. It was issued in 1996. And here it's topics, when you read it, it's about this thick, right? But it covers computer security, copyright protection, digital rights management, electronic contracts, virtual credit cards, how to distribute music and movies online. It covers just so much, right? And however, their product is not as well known, but they do have the patent. And again, think of Philo Farnsworth, right? And others. That one company, their patent was so strong, Apple had to license their technology, Microsoft, Huawei, Sony, and others, BBC, Adobe, they all pay intertrust. And they're even in relation in a venture with Google, right? So again, that patent allows this little guy to compete with the big guy, right? And when you think about that Follow Farnsworth story, that's why I talked about Granville T. Woods, because his story, Bell, it wasn't adversarial. Bell said, okay, hey, I'll buy your patent. It's such a good idea, I'll buy it. Edison tried to compete with him and Edison lost. So it's not always so, right? There's some happy endings too. Next slide. Name, image, and likeness. So it's kind of moot now, but for years, there was this controversy regarding should amateur athletes be paid, right? So you had the amateur athlete, in America, you had the amateur and you had the pro. And never the twain shall meet. They were two, there was a firewall, they didn't meet. Until a gentleman named Ed O'Bannon, who was a famous basketball player in the 90s, he played for UCLA, won national championship, went to the pros, pro career was in, but he eventually went to court and he sued EA Sports and he also sued the NCAA. And the outcome of those lawsuits was that college athletes should be compensated for the commercial use of their name, image, and likeness. In short, the nil. So as a result of that, if you kind of just Google it, it's a thriving market because that is, in essence, that is my intellectual property. Who I am is my intellectual property. You just can't use me without paying me. So now college athletes are being paid to sponsor products. You see them in TV commercials, they're social media influencers and the like. And so it's a thriving market and it's called the nil. Next slide. So an attorney once told me, he said, the purpose of a patent is not to sit in a drawer somewhere and gather dust, right? And as Juan alluded to earlier, in some ways, the patent is just the beginning. So here's some examples of that next step called the IP marketplace. So the IP3 is a secondary market for patent holders. Say, hey, I have my patent, but maybe like in the interest case, hey, I'm not able to bring it to market, but I do have the technology, right? Well, you can then put it out there and another company might say, hey, you know what? I can use that. So this system brings buyers and sellers of IP together. And some of the participants, some of the biggest names in the business, Google, Meta, because they're in Meta now, Ford, Microsoft, Honda, Verizon, some examples. Then building off the non-fungible token that I mentioned earlier, there's something called NFTU. So again, what is an NFT? Is a digital representation of an object that exists in the real world, art, music, videos, and the like. It can be based off of a virtual object. And that's when you look at the Martinez patent, what they were talking about was game abilities, spells, weapons, and the like, right? And then it can be bought and sold. But here they're stored on the blockchain. So what the NFTU is a marketplace for name, image, and likeness based NFTs, such as NFTs derived from college player highlights. So that's a quick summary of some of the activity around IP in the real world, how it is today, and how today people are problem solving. And if you have any questions, please feel free to ask. But I think that's the last slide. That's the last slide, Jorge.
It is, Calvin, and thank you. That's our, if you want to reach out to us and get in touch with us, our education inbox is education@uspto.gov. Please also come back to visit us at uspto.gov and also uspto.gov/kids for some of the activities that we went through today. So on behalf of the United States Patent and Trademark Office and my colleagues at the USPTO and our collaborators at the Conrad Foundation and students from across the US and in other parts of the world, thank you for joining today and learning a little bit about intellectual property and how it applies to your lives, to your futures, and to the amazing work that you're doing as part of the work that at the Conrad Foundation. I will open it up for questions. We can hang around for a little while longer. I know it's lunchtime around the the East Coast time, but some of you may be going to sleep or waking up. I don't know. So,
I have a quick question, Oria.
yep.
So on the NFT patent that was in 2000, does that have application now into the NFT universe, if you will?
Oh yeah, so it's so what was patented in 2000, it wasn't called NFTs.
Right.
They called it a limited edition digital object. And so it definitely has definitely has relevance today, because a lot of the elements of how NFTs are being used today are described there. The main difference is its relationship to the blockchain and how it's
Got
stored.
it. I got it. So once it goes into the blockchain, then that particular IP is different than what is going on now in the blockchain with the NFT. Is that correct?
Yes, that's the add-on.
Okay. But they don't own that piece of it. Whoever owns that patent doesn't own the secondary piece. So they got the plug without the socket.
Yes. And that's one of the sad things, but I remember looking at a patent when I was an examiner, and it was going back maybe like 81 or 79 or something. It was the early 80s. And it was so interesting that it was a cash register. It was a programmable cash register. And what it would do is it would print a receipt. And on the receipt, it would say, "Happy birthday." It would say, "Happy Thanksgiving." And here are the coupons. And what's so fascinating was, at the time, I remember those cash registers, they weren't saying anything, right? But they kind of didn't, they were so far ahead. And then there was another, another device I saw. It was like a portable, like phone that you can plug in a pad, a keypad, a biometric reader, all these different things. And in many ways, like, hey, that's Square. But how it's different, to your point, how it's different from Square is the connection. That patent used the PCMCIA protocol. Square uses USB.
Right.
So to your point, they couldn't sort of assert their rights of like, hey, because just in that terms of that connection.
Yeah, it was a different object. You know, which it really just validates. I mean, not that we're so perfect, but we're close. Because when you intersect design thinking with systems thinking, you really begin to understand how you not only have to make the plug, you have to make the socket.
Yes.
Fits into. And I think that's part of the special sauce of what we do with our students around the world. So thank you for that distinction. I think it really underscored how important it is to intersect design and systems thinking. Yes. Thank you. I think kids have questions. I don't want to rule the roost here.
Chris, I think there was some question about they wanted more information about how to complete or submit a provisional application. And thank you, Chris, for putting in a link. There's actually a lot of stuff on our website in terms of, how to step by step. We also have the USPTO has a YouTube channel with lots and lots of great resources. And one day I met one student, a high school student actually from California, who pulled his provisional application for patent and wanted me to look at it. And I said, no, I don't want to look at it. Put it back in your bag, in your backpack. But I asked him, well, how did you figure this out? And he did it on his own. He said, I watched a bunch of YouTube videos and I learned how to, write up a provisional application. Now, while the USPTO on our website does not recommend necessarily that, you do this solo and that you secure, an intellectual property attorney, particularly for the non-provisional application, which has all of the bells and whistles that patent examiners like Juan and Calvin need to have to be able to make an assessment and adjudicate, if you will, whether or not it should receive a United States patent and meet the the criteria for patent. there are some people who do that, and we have special groups within the USPTO who handle applications from inventors who decide to pursue the application drafting and submission on their own. And so I don't know if Calvin or Juan can speak a little bit to that. We have other programs as well too, pro bono program that is an application program where you apply, and if you get selected, basically you get free legal advice to help you and support you on the application and prosecution of the of your patent application.
So may I just add a little footnote to that?
Yes.
Footnotes, actually. There are tools and resources on the Conrad Challenge site for the provisional patent. And then one of our awards, as you probably know, is IP. And so that is done pro bono with some of the large law firms that work with us, like Denton's and Aaron Fox. So that's just information gathering.
Yeah, thank you, Nancy. We're excited. I know Hope Shimabuku, our director of the regional office in Texas, will be attending in person at the Johnson Space Center in Houston. So we're excited that she'll have that opportunity to speak to the students.
Yeah, somebody wanted to know how much that costs. Big bucks. So it doesn't cost our students anything when they get a provisional, when they get a patent through it's one of the prizes for our competition.
Yeah, I remember. Yeah, I remember when I was in graduate school, because I think Joyce and Juan could speak to this. I think they're like libraries across the United States that will allow you to search in different things. I remember. So I'm kind of like a cheat code at the patent office. I mean, I'm an exam manager now, but when I remember when my daughter was born, she, babies are slippery. So when I bathed her, I didn't want to drop her. I was like, oh my God, I want to get my daughter. And the funny thing was, so I said, oh man, it would be pretty cool if you had like a liner that you can put inside the tub that, the child would, like, oh, they could bounce, like, oh, they're great. And, so I designed, my sister's an artist, so we basically came up with it. And I didn't go through the process, but what it was very helpful, for the first time I searched. So I went to the Carnegie Library, because I was in grad school at Pitt. I went to the Carnegie Library in Pittsburgh and I was searching. And I think so there are certain public resources. I don't know, I mean, again, Joyce and Juan can build on that, but there are resources available around the United States. There's certain libraries you can go to that will allow you to, for example, search and do some of the things that help you along your way in your journey to invention.
Thank you. Glad you didn't.
All right. Any other questions? I think it's time to have some lunch if there are no other questions. Again, thank you, everyone on the USPTO team, Nancy, Simon, and Jack, I think, joined us in the beginning part. Kristen, of course. She has been tremendous in pulling all of this stuff together and making sure all these pieces connect and organized in a way that we can do today's program.
Amrutha has her hand up.
Oh, okay.
I'm not sure if this would be answered in the website, but how to get small entity status or like micro entity status, and also how many patent or patent drawings should we include in our application?
Well, as part of your filing, you would file for like a small entity.
Okay.
But there's no sort of limit to how many drawings that you have. I mean, I've seen patents without drawings, but it's basically, again, disclosure. And because it's sort of like this sort of back and forth, right? The more you have in there is always to your advantage, because it helps you, because it allows you to articulate what you're doing.
Okay.
At the same time, right, it also gives you more to go on. So let's say you have one figure, right? But maybe if you had a couple more figures, it all depends on what you're trying to come up with. You can have different embodiments, different descriptions, right? Which then like those drawings tie into your actual, it's called the detailed description, right? So don't think of it as more or less you just use, I had a professor one time called minimal essential information, but you basically have enough in there to make your case. And what's also because it is an adversarial system, we're going to do is like, if someone said, hey, I have this device that can track your performance while you're jogging, and you know, like no one has ever done that before, then you have the 1973 jogging computer, right? So the point is, the more you have in there, the more you can draw from, because it's a back and forth. So maybe the first time around, you might get a rejection, but then because in your specification, your drawings and your detailed description, you will see, oh, I can pull this in, right? So it's not about how many, it's about, is it enough that you're satisfied with your description? And as Nancy was saying, that you kind of have, you don't want to get in that challenge where you didn't have enough so that someone can easily design around it, right? You have to, it has to be broad enough. Like the example was, this person had basically square. It was basically square. The only difference is the plug. And maybe instead of being it so narrow, say call it a PCM-CIA connection, you would say a port, right?
Yeah.
And you give different examples, and your drawing might be, so you might have like the piece, like the actual how it's working right now, but you'll have another drawing which talks about what it could look like in 4 or 5 years, something like that, and you make it sort of a little generic. So there's no limit on how many or how little, but you just have enough so that you can fully describe your idea.
Okay, thank you so much.